Да, точно. 26-й, все правильно.
Добрый день.
Конференция пока не началась. Отключите пока, пожалуйста, звук.
Да, хорошо.
Да, я слышала.
Я пришла на конференцию.
Ковид.
Часа.
Ковид, да?
Да.
Угу. Вы как слушатель, получается?
Я как слушатель, да.
А можете, пожалуйста, фамилию сказать?
Сигарева. Меня нету в...
Списках?
Да. Ну, я студент, пришла послушать, и я хочу, скорее всего, к вам зайти, направить, поэтому участие необходимо.
Вы присаживайтесь тогда.
Коллеги, я прошу прощения, мы можем уже запускать, нет?
Как выпускать участников?
Да, участников.
А я не
Да.
вижу в зале ожидания больше никого.
А вот только что были.
А сейчас уже никого нет.
Угу. Но мы
Просто-
же можем, нет, запускать? Мне про заведующий нас тоже спрашивает.
Ну да, я думаю, можем.
Ага.
Я специально здесь сижу, жду, чтобы запускать.
Все, поняла, спасибо.
Мгм.
Коллеги, добрый день.
Я не знаю.
Пользователь паспорт.
Алло, слышно меня? Hello? John?
Hello.
Hello. John, how are you? Are you hear me?
Yes.
Hi, John, how are you? Hello, John. Are you hear me?
Okay, can you hear me now?
Yes, I can. Yes, I can. Thank you. Thank you. How are you today?
I'm well, thank you. Yes.
Are you ready?
Just about.
Okay, so Alisa, how many people do we have now?
I think we have 14 people.
We have 14 people
Yeah.
already, John. I know that you will not start unless we have at least 25, 30 people.
I'll be gone by the time we get to 25, 30 people.
Okay, maybe Alisa, could you please give the rights for display?
Yeah, I have them here.
You have them. Okay.
Yeah, but I wasn't going to
Already
put
did it.
I wasn't going to put them up until we were ready. Okay.
Okay.
Spoil all the fun.
So you've told me about the Charles, yes?
No, not Charles. It was
Not-
Prince Philip.
Prince
Yeah.
Philip. Yeah, sorry.
He would have been 100 in June.
Yeah, 100 in June. So
Yeah.
when he was born, what date exactly? The first, second?
I'm not sure what date in June it was, but it was June.
Because I was born on the 1st of June. So
I think he was about the 9th of June, I think.
okay.
But he's been ill for quite a while. They are the longest serving married monarchs in history.
Mm-hmm.
Been married a long time.
So all people are sad now in the UK, yes?
Sorry?
All people sad now in the UK.
Well, not all, but the very vast majority will be, yeah. I mean, we've been expecting it for some time because he was in hospital over Christmas and nobody actually knew what was wrong with him.
he was deeply, as far as I know, he was deeply involved in some environmental issues. He was the president of some organizations or one organization, some kind of wild support organization or something like that.
He was. Prince Charles is more involved.
Ah,
He's very involved. He talks to plants, so you know he's and to trees and things. But no, well, let's see what happens with the Queen. But I would imagine she will be deeply upset, and we will see.
okay, shall we start?
Whenever you're
Olesya,
ready.
or will we wait some time? What do you think?
It's up to you.
No, I think we have enough participants to start.
So let me start our conference. Dear participants, thank you for joining us today. And we start our conference. The topic of this conference is international commercial contracts and the outbreak of the COVID-19. And I'm happy to introduce you, my friend and my teacher, Mr. John Sykes. He is an international charter insurance law adjuster. He has a very deep experience in sphere of insurance law, and he practiced he practiced insurance for 40 years or something like that. And I asked John to give us some presentation about business interruption in the UK insurance market, but I also asked him to describe to us a little bit the insurance market in the UK in general. So, and my suggestion is John will give his presentation for 15, 20, 25 minutes, as much as he wants, and then we will ask him questions to clarify some of his ideas. And basically, I would like to underline that our conference, it would be better if our conference would be like more question and answer format, in format of questions and answers, because we definitely need to use this possibility to speak with native speakers, ask him to share with us his thoughts and ideas about insurance market in the UK. We've discussed with John insurance market in the UK many times on different occasions, and this is time when John will share with his knowledge with all of us. Thank you, John, for joining us, and we are all ears.
Okay, thank you, Professor Kanaszewski.
Yeah.
Thank you for inviting me here. I got it right. Thank you for inviting me here this afternoon. I'm going to review a little bit, a very quick bit about myself, and then I'll give you a bit of information of Lloyd's of London, which of course is where insurance all started. Just a couple of little tidbits that you may not know about the beginning of insurance. We're going back nearly, 500 years, so 500 years. But anyway, let me just bring this up first of all, and we will take it from there. And we were just talking beforehand, unfortunately, here in the UK, Prince Philip, who is the husband of our Queen, unfortunately died this morning at the age of 99. But this happens occasionally, and it has resulted. Well, it's a sad time, but he's been ill for a long time, longest serving monarch that we've ever had. So, okay. What I was going to talk about today is primarily business interruption insurance, the UK, and COVID-19. And the reason I brought this up, and the reason Vladimir asked me to talk about this, was because of a major court case at the Supreme Court in London, which came to judgment in January, and it has caused quite a lot of controversy within the insurance market, and it all relates to COVID-19. But first of all, let me give you a little bit of background about myself. As Vladimir said, I've been in insurance for quite a number of years. I started off with the Royal Insurance Group, which is still around, but now known as the Royal Sun Alliance Insurance Group. And I started with them in 1968. I spent 2 years training there. And in 1970, I decided I was going to concentrate on claims. And I was lucky enough to join a firm of loss adjusters called Thomas Howell Self and Company, one of the big boys in the UK at the time. I was with them for 6 years. During that period of time, I dealt with bomb damage claims in Northern Ireland, where there was a lot of trouble going on. And I served in other offices, Stoke-on-Trent, Birmingham, Stafford, I think was the other one. However, in 1976, I was approached by the Graham Miller Group, which was an international firm of loss adjusters, and invited to join them. So I did, and I was posted out to Nigeria, beautiful country. I was there for about 18 months, and then I moved on to Saudi Arabia, and I was in Saudi for a while when I received a call to go to Iran. And I remember the date, it was the 21st of December, 1978, just when the Shah was leaving Iran and Ayatollah Khomeini was coming in. There'd been a major fire up in the Caspian Sea, up in the north of Iran. And it was a power station under construction, and the entire power station had been burnt out. What the insurers were concerned about was the cause of the fire. Was it accidental or was it deliberate as a result of the revolution that was going on? That ended up being one of the biggest claims I've ever dealt with, because it was in the tens of millions of dollars final settlement. Anyway, I stayed in Iran. I couldn't get out because of the revolution. I eventually got out in March, went back to London, was offered to go back to Nigeria or Iran. Well, you'll forgive me, but if you've ever been to Nigeria, you might accept why I went back to Iran for another 18 months. But in August that year, we decided to close Iran because it was impossible to work anymore. And I went to Dubai and opened up an office there for them. And we covered an area from Cairo to Singapore and all of Africa. My speciality was major fire claims, consequential loss claims associated with fire or material damage, marine fraud, and workmen's compensation claims for the American offshore oil industry. In 1984, circumstances were changing, and so I set up my own business and secured a license to trade out of Dubai, which I did for quite a considerable number of years. But by that stage, Dubai was changing, the industry was changing, and I decided I'd had enough. I'd spent many years traveling. I was tired. I was going to retire, and so I did. I came back to the UK, and I have to tell you, after 3 months, I was that bored. I didn't know what to do with myself. And so I decided to, this might amuse some of you, but for some unknown reason, I decided I was going to learn Russian. Please don't ask me why, because I don't remember. But I joined a website, which everybody helped everybody else, and decided I would learn Russian. When they discovered I was British, everybody was asking, could you help me with this? Could you help me with that? I never learned a word of Russian, but what I did do was discover that I could help people with their English. So I took 6 months off and I went and qualified properly to teach English online. And I've been doing it ever since. That's for 10 years, nearly 11 years now. I work primarily with senior business executives and academics and people wanting to go to university to help them either improve their English or pass exams. Okay, so going back to the history of things, let us have a look, first of all, a little bit about Lloyd's, because Lloyd's is, as I said, where insurance all started. The first mention we have of Lloyd's is way back in 1688, and it was in a coffee house, Tower Street, owned by a Mr. Edward Lloyd. And what used to happen there was trading merchants and what was the early stage of insurance. They used to meet there for coffee, discuss about the trading market, discuss how the ships were traveling. And it was mentioned for the first time in the London Gazette, a very famous London newspaper, which is still published to this day. Moving on from there, in 1734, Lloyd's List appeared. Now, if any of you are involved in the marine or insurance industry in any way, Lloyd's List is invaluable because it records and traces the progression of any vessel anywhere in the world. And they get this information from various representatives in the ports. It was that good that the British Admiralty actually used Lloyd's List to find out where their own ships were, because their information wasn't as good as Lloyd's. Having gone on from that, we then had a situation where the first detail of 1750 was when underwriting first appeared. There's no real record of how this started, but it is said that a Quaker businessman in 1757 actually went into Lloyd's coffee house and subscribed to the insurance book, the princely sum of 2 guineas a year. Now, 2 guineas is the equivalent in what we call old money of £2, 2 shillings, which I suppose would be £2, 2 shillings would be 40p. Cost you a lot more. And the only reason we know that was because he had written all that in his journal. So that's the actual first record of underwriting. Trading went on, but in 1764, there was a very important court case. There was a vessel called Mill's Frigate, and there was a claim intimated for the destruction of this vessel. It actually sank. And what was decided was the vessel actually was weak, leaky, and in a distressed condition. And the ultimate decision was, the court decided, that a ship must be seaworthy before leaving shore, and that a policy could not even be paid on a ship which suffered from a latent defect unknown to both parties and the contract. That caused absolute chaos in London at the time, but in due course, that actually formed a major part of English law for marine insurance as we know it today. Now, carrying on during the 60s, insurance underwriters, people investing in Lloyd's, they were making good money, very good money, and they started to take on all sorts of risky cover. For example, they used to take things like highway robbery, death by gin drinking, and things like that. But there was a group within Lloyd's who said, no, we're not doing this. Let's have a bit of professionalism in it. And they pulled away, and they actually went to another place at 5 Pope's Head Alley in London, which was also called Lloyd's. It was another Lloyd's coffee shop. And they created the professionalism and order that we now have in insurance. The other lot eventually died off because they just drank themselves and bet themselves to death. In 1773, we have the first known indication of the principle of lead underwriter. Now, what that means is with a major insurance policy, one company or one underwriter does not take 100% of the risk. You have what's called a lead underwriter. They set the terms, they set the premium, they set the percentage, and then other underwriters fall in underneath and accept the risk based on the terms set up by the lead underwriter. And a guy called John Julius Angerstein, who incidentally was a friend of Lord Nelson, he set up the idea of the lead underwriter so they could share the risk. And from there on, these sorts of policies were known as Julians after him. And it was the basis for all insurance for the future. One final point, in virtually every marine city, town in the world, you will find a Lloyd's agent. And the Lloyd's agent is there to assist with insurance queries, vessel location, anything else dealing with Lloyd's. And to this day, there is a huge network of Lloyd's agents. Okay, those are just some points following on from Lloyd's insurance. And of course, all insurance is covered from them. Now, we all know about COVID-19, and we all know how this has affected businesses throughout the world, none less than in the UK. We are still under lockdown. In Northern Ireland, we have been under virtual permanent lockdown since October, but for a period of 2 weeks. England, Scotland, Wales are now coming out of lockdown. Unfortunately, we are still in it. How long we're going to be, I have no idea, because our government officials are quite incapable of making decisions, so they can't tell us when they're going to release us. But there's no doubt that the economy worldwide has been badly affected. And the question was, can insurance companies be forced to pay out under business interruption insurance? And as a result of this, there was claims intimated and many claims turned down. But in last year, a court case was taken to the High Court in London, and they made a decision, and it wasn't favorable to the insured. Let me explain, first of all, the two different types of business interruption insurance. The first type is where you have business interruption following material damage. In other words, if you have a factory and the factory is damaged by fire or flood or impact or hurricane or something like that, it follows on that there will be an interruption to that business whilst the premises are rebuilt or equipment reinstalled, etc. And therefore there would be a loss of profit or a consequential loss claim, which follows on. However, there is an exception, there is an extension to that business interruption, which, as a result of a premises being closed and forbidden to trade by the government, there could be a loss of business interruption following this action. Now, the policy was primarily intended for closure from localized diseases or from contamination within a restricted area, normally 5 miles. It was never intended to cover closure as a result of a pandemic such as COVID-19. Nobody thought about that, and the policy wasn't written that way. It wasn't written that way to exclude it, but at the same time, it didn't specifically include it. And this is what all the court cases were about. Was it coverable or not? Now, I'm going to give you, these are just examples of cover. If you want to, we can go into more detail later. But for a material or a claim resulting from material damage, excuse me, business interruption shall mean a loss resulting from the interruption of or interference with the business carried on by you, in other words, the insured, at the premises in consequence of loss of or destruction of or damage insured under particular section to the property used by you at the premises for the purpose of the business. In other words, the factory is destroyed, you have a result in reduction of turnover, you have a loss. That's a material damage business interruption claim. Excuse me just one moment. Business interruption resulting from notifiable disease. Now, a notifiable disease is where you are compelled to notify a local authority. COVID-19 is one of those diseases, although not defined as such. But it means that illness sustained by any person resulting from any human infection or human contagious disease, an outbreak of which the competent local authority has stipulated shall be notified to them, with the specific exclusion of acquired immune deficiency syndrome, AIDS, an AIDS-related condition, or avian influenza. That is the closest they get to naming a type of pandemic, okay? Because there was a huge pandemic resulting from that. So let's now look at what happened. Here is the forefront to the 114-page summary of the judgment. I have copies of this if you want them. It's very boring reading, I can assure you. But what happened was there was an initial claim by the Financial Conduct Agency. Now, that's a regulatory body in the UK that controls everything to do with finance, whether it's insurance, money lending, whatever it may be. The banks are followed under this. And a lot of complaints were lodged with the FCA about the decision of insurance companies turning down claims. So they went to the High Court. And in essence, the High Court favored a judgment for the insurers. The FCA were not happy about this and they wanted to appeal. Now, the next progression is you go High Court, Court of Appeal, Supreme Court. At this time, there was reckoned to be something in the region of 370,000 potential claimants, which is quite a lot. And because of the urgency, the Supreme Court accepted that the case could be brought directly to them without going to the Court of Appeal. So this decision is the final one. There is nowhere else for anybody to go, whether they like the decision or not. They decided to take 8 insurance companies. There were hundreds of insurance companies or underwriters involved. And they used 21 different policy wordings. And the poor old judge had to go through all the 21 different wordings and summarize them and look at them all. But he used those as a basics. And it was agreed that the insurance companies would accept this as a presentation of their case. They had also agreed that this would be a test case, and based on the decision, they would entertain claims accordingly. Okay. As I say, the whole thing runs into 114 pages, which is quite a bit of reading. But the ruling that the judge has made does not mean that policy holders definitely do have business interruption cover, that their claims will be paid. What it does mean, though, that those policy holders that were deemed to have no claims resulting from the High Court decision may now have a claim resulting from this ruling. And that makes a big difference because a lot of companies a lot of insureds either didn't claim or had their claim turned down. Now they can go back and they can start the whole process again. What they did was the judgment's conclusion looked at 6 different points. He looked at the application of a disease clause, the prevention of access and hybrid clauses. In other words, did people have access to uninsured premises? Causation, what was the cause? Trends clauses, this related to how claims were going to be judged. Pre-trigger losses, this related to events that happened before the claim was actually intimated. And then they also looked at a court case in America called the Orient Express case. And this was a hotel in Houston, and I will come in New Orleans, sorry. And I will come to this in a minute because it had a major ruling on the causation. Let's have a look at the first one, the disease clause. This provided cover resulting for an occurrence of a notifiable disease at or within a specified distance of the insured premises. And this is what the judge was looking into. What he found was that each case of COVID-19 is a separate occurrence. And these clauses only cover BI claims resulting from cases of diseases occurring within the specified area. In other words, if there was a case of COVID-19 in Birmingham, which is in the center of the UK, but people were worried and wouldn't go into premises in, let's say, Manchester, which was further up, that wouldn't apply. It had to be close. The distances were different. They could be anything between 5 and 25 miles, but because we had COVID, you could be sure that there was somebody close by that had the COVID. Now, this was a more narrow definition than the High Court, because the court agreed that the policy wordings were not expressed and only applied to instances of illness within the specified distance. And claims could apply in the circumstances of a pandemic. So once a pandemic was declared, didn't matter where you were, okay? You were deemed to be within the specified area. The next clause we looked at was prevention of access and hybrid clauses. These basically are clauses which specify what requirements that must be met before an insurer is liable to pay. Now, for this purpose, the judge used one particular policy and the wording of one of Hiscox's policies. And the court ruled that cover would be provided when a policyholder is unable to use their premises for a discrete or specific business activity as declared in the insurance policy. So if somebody ran a pub and they were forced to close, they couldn't open it up as a record store and claim for business interruption insurance because that business was not the insured business. The result of this meant that under the High Court ruling, people may not have a claim, but now this opened it wide again and has enabled those who were turned down by the High Court to possibly have a valid claim to be considered in the future. Causation. Now, this is a bit complicated, so I hope I can explain it as best as possible for you. The policyholder under a disease clause must show that at least one case of COVID-19 existed in the specified area at the time of the government measure. The government measure was when they issued the order, close, everybody must close, otherwise known as lockdown. There must be a sequence of events as defined in the policy, but the fact that companies suffered losses resulting from COVID prior to intimating a claim, i.e. prior to the government enforcing lockdown, these could not be excluded from the calculation of a claim, whereas under the High Court, they could. Before we had a situation where we had lockdown, people weren't going out. People were scared of COVID-19. They were worried about if they went to shops, if they went to work, they could contract COVID-19. So they weren't going. So as a result, turnover was substantially reduced. Under the High Court ruling, they said that this must be could not be taken into consideration when calculating a claim. The Supreme Court said, yeah, it can be. And this had a major effect on things and will do in the future calculation. Trends clause. In any business, it goes through trends. Last year, things might have depressed in turnover. The previous year, they could have been on an increase. This year, forecasts could have shown, yes, we're going to be on an increase as well. However, as a result of COVID, many companies, the trend was downwards because they just weren't able to trade. They were closed. That was it. Yes, a lot of them adapted quickly and did online trading and were very successful in it. You just need to ask Mr. Jeff Bezos of Amazon. He's done very well out of it indeed. And a lot of other companies have. You cannot make adjustments to cover by the effects of COVID-19. You cannot exclude a regression resulting from COVID-19. And what it means is that whilst prior to the close down, companies were reducing turnover as a result of COVID-19, that has to be considered as a non-trend and cannot be used in the calculation of claims. And again, I will come to that in a little bit. It was known as the pre-trigger loss. The decision was made that for a claimant to calculate a claim, it must be based on the previous year's turnover figures. If turnover had reduced as a direct result of COVID, then this could not be considered as being an overall business reduction in turnover. This was previously excluded. And it now must be taken into account when calculating any loss, okay? Whereas before it would have been ignored. If you want further clarification on that, I will try and give it, okay? The Orient Express case. In New Orleans, there was a major hurricane. As a result, a hotel did not have any business, although the hotel itself was not damaged. And in America, the case was decided that cover did not exist because it would have occurred, the losses would have occurred anyway as a result of damage to the city. The judge here said that was a wrong decision and it should be overruled. And what he has now said is basically, yes, there was a result of business interruption resulting from the fact the whole city was damaged, even though the hotel wasn't damaged, and therefore a claim should be met. This has a major effect on the ruling here, because it goes back to damage resulting from people not coming out. The High Court said, oh no, that's not claimable. The Supreme Court has said, yes, it is, and it must be considered. So what has happened is it has changed the whole thing from the High Court ruling, which basically said if you resulted from had a loss resulting from reduction in turnover prior to the government closing everything down, it's not covered. The Supreme Court said, yep, it is covered and it must be taken into consideration when you're assessing what the turnover was the previous year to the closure. And this has caused major concern with the insurance industry. It's great for policyholders because their position has now been strengthened. Those that had had claims previously turned down may have a chance to try again. Those who are still fighting, the ruling is on their side. Remember, with the Supreme Court ruling, it cannot be appealed. That's it. That's the final decision. As a result, insurers now face a possible 370,000 plus claims, and it's estimated this could well amount in excess of £1.5 billion of claims to be paid. They can now review their wordings, and within the definitions made in this decision, they can pay claims accordingly. Now, the FCA made a declaration that they will be working with insurers to ensure that they now move quickly to pay claims that the judgment says should be paid, and where possible, make an interim payment. I can tell you from little bits and pieces I've heard, including, funnily enough, a mention on Twitter last night from a gentleman in Wales saying that his insurance company are turning down his claim. This is still dragging on. Insurance companies are not rushing to pay claims. As they do these days, they seem to use every excuse possible not to claim. And I can see that in due course, there will be another court case, but it'll be against an individual insurance company. And it won't be a test case, it'll be an actual case. Where does insurance go in the future? Well, insurance is nationalized. Will we be able to get business interruption cover of this type in the future? I very much doubt it. I think policies will be reworded with the minimum amount of cover that they will be forced to give. It'll be difficult, but it'll also be carefully worded to include other diseases outside pandemics. How they'll word it, I don't know. Insurance generally is changing. The big insurance company, the first one I worked for, Royal Sun Alliance, has just been bought out by a mammoth American company. So what you're going to end up is with mammoth groups of companies owning the vast majority of insurance. It's going to be heavily controlled. The maximum that we pay claims promptly has disappeared. Insurance companies now fight every claim. It doesn't matter what it is. And they will do their best on that. We now have a situation where we've got various insurance companies, such as one in America called Lemonade. They don't work on the proper basis of insurance. The way they operate is they come with a premium. They take a fee for producing that, and then they put an amount aside for potential claims, and then they say they give the rest to charity. Well, that's fine if you're only dealing with householders, cars, etc. But if you go into the commercial world, it's a different ball game. And how that's going to progress in the future, I don't know. But as a result of this, I can see a major turn in the way insurance will develop in the future, particularly with digitalization that we have. I hope that helps you. I hope it gives you some idea of what's been going on here in the UK. If you want a copy of the court judgment, you can email me direct and I'll be more than happy to send you the PDF of it. Save you searching for it on the internet. Thanks very much for your attention.
Thank you very much, John. It was really interesting, very clear language, and I'm happy to hear you. And of course, I'm envying you because you have so perfect language. I have one question. Just not, I have many of them, but one question. You mentioned in the last slide that the regulator, FCA,
Yeah, Financial Conduct Authority.
okay, FCA as a regulator has some authorities to push insurance companies to pay, yes? So I'm just interested how it is in practice. For example, I have a claim, business interruption, and the insurance company is supposed to pay, but it doesn't pay. What should be the course of action? What is the course of action for me? Should I go to the court, which is kind of expensive, or I need to, or I may to apply to FCA and ask them to push the company to pay me a compensation? What do you think?
You can ask the FCA to look into the case. They won't necessarily, and this can be anything to do with banking, investments, anything like that. You can contact the FCA. They will not necessarily push the insurance company, but they will find out the insurance company's reasons for turning down your claim. And then you can decide from there whether you want to go as an individual and take the insurance company to court. The reason the FCA got involved here directly was because of the vast amount of claimants. It couldn't be done individually. It had to be done on a select basis, select number of insurance companies, select number of policy wordings, and the FCA representing all claimants. That was the only way it could be done. It couldn't have been done by individual claims.
Okay, and the next question is, when you described this case, this high court case, you mentioned that the judge referred to the U.S. case. I don't remember the name of the state.
Yeah, the Orient Express Hotel.
Yeah, the question is it possible for the UK judges to refer to the foreign case law, as in this case?
Yes, because this was one of the cases that had been pushed through as by the insurance companies, and they had used this as a basis, or some of them had used it as a basis for turning down claims. So whilst he can't actually change the law in America, he can look at it and say, I don't agree with this, therefore you can't apply it. He can't change the decision of the court, but he can, same as you can in your country, you can say, okay, there's been something happening in the UK. We don't agree with that decision. This is our decision. And that's what he did.
Okay, thank you. And any other questions from the participants?
May I ask a question?
Yes, go ahead.
Good afternoon, Mr. Sykes. Thank you very much for this interesting report. I have actually two questions. The first one, when you were talking about the turnover analysis, how far do they go in analyzing the turnover?
1 year.
1 year, 1 year.
The previous year.
But there might be some companies that were very bad in the beginning. Then there was this 1 year, which was very successful, but then they go into the COVID. So still 1 year.
Tough is basically what I can say. There had to be some line drawn, and so it was decided on 1 year.
And the second question will be, did this affect in any way the contract practice in the insurance companies? I mean, do they change their clauses? Do they make it more specific in order not to allow them to go into the COVID pandemic?
They will probably do that, yes. In fact, I have no doubt that they will, because, as I said at the early stages, the business interruption disease section was not intended for pandemics. It just wasn't there. And so they've been caught out. So yes, I have no doubt that they will rewrite the wording. It'll never be a standard wording. Different companies will rewrite different things. But no, they won't want to go through this again. And whether we like it or not, and I'm not a forecaster, there are going to be other pandemics. No question about it.
Yeah. Thank you very much.
You're welcome.
Any other questions? So no questions from the people. I have a question. My question is concerning the term underwriting. Underwriter.
Mhm.
What does it mean? Underwriter is someone who is underwrites in the insurance policy. Yes?
Underwrites the risk.
Underwrites the risk.
Mhm. Yeah, that's what
And
they
who, and who are them? Are they individuals or are they companies, or do they need a license? Do they have to be licensed? Or for example, can I, as a citizen of the Russian Federation without any background in the UK law, can I be or may I be underwriter?
You wouldn't be an underwriter. And now we're talking Lloyd's here only because insurance companies are completely different. In Lloyd's, you have what are called names. And if you've got enough money, you can be a name. You then join an underwriting syndicate, which is a group of names. That syndicate then appoint an underwriting agent, a managing agent, sorry. And it is the managing agent that does the actual underwriting itself. Anybody can be a name. Yes, there are certain terms and conditions. It was changed a number of years back where you could be personally held liable to the full extent of your assets and everything. That has been limited slightly, but you still need a fair bit of money to be a name. And a lot of wealthy people of all different types from all around the world are names. In fact, I remember back in my earlier days that you weren't considered rich unless you were a name at Lloyd's.
And the question, I have also a question related to your specialty. What does it mean? Loss adjuster. What was your job? You know, what
Well, in
action you were
reality, I mean,
supposed
we adjusted the losses. Our function was always to be an independent investigator and negotiator of settlement of a claim. A loss adjuster is appointed by an insurance company. Yes, the insurance company pay the fee, but our job is to be there and find out what the cause of the claim was. Was that covered under the policy? And then negotiate settlement within the terms and conditions of the policy. For example, we're looking for proximate cause. In other words, what caused the fire? Was it a little electrical short circuit, which then caused a bigger fire, which caused something else? Proximate cause is that initial incident that sets in motion a train of events that brings about the result, the destruction of the building. If you have, for example, a 3-year-old car and it's damaged completely in a crash and you claim under your insurance company, the insurance company will not give you the price of a new car. They will give you the value of a 3-year-old car. It's the same with indemnity under a material insurance claim. There will be equipment in a factory that's not new. There will be computer systems that aren't new. The insurer's job is, well, our job was to estimate what was the actual value of that equipment at the time of the loss. And this, of course, is where a lot of arguments would come into play as to what the actual value was. And once that was accepted and we agreed settlement, then that claim would be reported to the insurance company and they would then pay according to our report. They didn't argue with us. What we said went. When it came to consequential loss, that's a different ball game. I mean, you're into a whole lot of figures. As you asked me, what about previous years? Yeah, we would have had to go back into all of that, look at trends, etc. What were standing charges? What were regular payments? All of this that came into consequential loss claims. And not everybody dealt with consequential loss claims. Just for the record, my father actually was also in insurance and his entire life with the Royal Insurance Company. When he retired, he was reckoned to be one of the top loss of profits insurance people in Europe because there weren't many specialists, and that's what he had, an accountant's mind, and that's what he specialized in. There are very few experts in that field these days.
And the question, which is also in my particular interest, what does it mean, consequential loss? I remember we discussed this issue with you, I don't know, a couple of years ago.
It's a financial loss resulting as from a consequence of another damage.
Could you please elaborate a little bit? I mean, maybe you can give us some example. For example,
well, you have as a result of a fire. As a result of COVID-19, there is a consequential loss coming from the initial cause, which is COVID-19. So it's a as a result of one incident happening, another occurs. Okay, and that's the consequential loss.
So basically,
it's referred to as a number of things. It can be referred to as consequential loss, loss of profits, business interruption. It has various terminologies.
Okay, so okay, do you have other participants? Do you have any questions? I have one more question because my colleagues keep silence. They're a little bit shy, you know. They have more advanced language that I have, but I'm not a shy person, you know.
Forgive me, but you're all law professors. I've never met a shy law person.
Me, I was a shy person before I met you. Perhaps you've told us that this case, which was considered by High Court, will have enormous influence on the UK.
Supreme Court.
Or Supreme Court will have.
High Court, Court of Appeals, Supreme Court.
Yes, will have influence on your insurance market and internal business market as a whole. My question is, what happens if, for example, insurance company will just not pay?
The decision is already made. If they refuse to pay, then the person can take them to court and cite this court the decision.
Okay,
yep.
But many companies, because of the COVID-19, many companies went to bankrupt. Now they don't have money to go to the court to pay for this all costs, you know, and fees.
I haven't heard of any companies going bankrupt here.
What?
I haven't heard of any UK companies going bankrupt yet.
So you don't have, so they didn't.
Not yet.
Not yet, even one.
No.
And what about personal businesses?
Pardon?
The small businesses, the ones that the restaurants,
the small businesses, but the insurance companies haven't gone back.
No, I was not talking about insurance companies. I'm talking about the clients of the insurance
there's
companies.
many of them gone bust, yes.
Okay.
And there will be many more.
Many of them went to bankrupt, and now they do not have any money to pay for the cost fees. Maybe it is a good strategy for the insurance company just do not pay to them because you know, they will never appear in the court. They don't have money, you know.
Well, we have a legal aid system, and whether that can be brought in, I don't know enough about it to decide. But I think that with this Supreme Court ruling, that an insurance company would need to be very, very sure of its grounds before turning down a claim. Would need to be very sure, because it's in direct contravention of what the decision has been given.
Mm-hmm. Okay, any other questions from the audience? Alexander Kovalyov.
Go ahead.
Okay.
You were talking about these different clauses. I mean, the 6 of them. Do they usually apply all 6 of them in the contracts? Do they stipulate 1, 2, or maybe all of them are included into the contract?
Normally all of them, but it's the interpretation. They're not specified as contract. It's how they're incorporated in the policy.
So if I have several clauses, like the one with the turnover clause, the other one with the pandemic clause and all this stuff, so I may consider myself protected over all the losses. And if I forget about one, so this means that I'm protected only from another one clauses.
It would all be within the policy. It's unlikely. The purpose of this this court case was to give a clearer definition as to what was involved. For example, we talked about, I haven't got the sheets in front of me, just one second. I've forgotten which clause it was. How come computers never work when you want them to? We were looking at the causation. In other words, what was the cause of the damage? That was defining it more. So the trends clause, the pre-trigger loss, okay, not so much a clause, but a definition as to what could be considered as a coverable item, which if you had a loss of turnover resulting from lack of visitors to your premises as a result of COVID, that is covered, or that should be taken into consideration when determining the trend. So it was more clarification.
I think it's a bit hard to prove sometimes. If we have this pandemic, everybody will say that well, we have this problem with the overall custom visitations, but we do know that sometimes it could have happened just right before the pandemic, but people could have stopped coming there, and then this pandemic, and they say, oh, pandemic, now we have protection, and they can use it.
No, because I mean, your natural trend, you would have a look at your figures. I mean, remember, we're looking at a year's previous figures. So we would have had turnover before then, and we can look at previous years before that. To calculate the loss, we're looking at the 1 year, but we can look at previous trends to see how that has affected the business.
So you can still use the previous years in order to show that, well, sometimes this is not the correct numbers?
Correct. Yeah. You got to remember, an insured has got to substantiate his claim. It's his job to prove his claim. You know, it's not for the insurance company to say, oh, well, look, if you give us 6 years figures, we'll prove to you that. That's not the way it works, I'm afraid. You know, in the early days, I remember, I mean, just when I first started in insurance, if you had, say, a simple household storm claim and your chimney was blown down or there was roof damage, you could turn around to the insurance company and say, oh, I had a storm. When was it? It was sometime in the last month or so. Okay, no problem. We'll pay the claim. Now, day, time, etc., and they'll whip up the weather details for your house at that particular time and say, nope, there wasn't a storm. It was the following day or something like that. It's up to you to prove your loss.
Mr. John, if I, for example, insure a person and I want to get a compensation from the insurance company, and how I can prove that the number of so basically I can use, from my perspective, I can rely only on the accounting documentation from the previous years. This is the only evidence or proof I can bring to the court, because, for example, if it comes to the court proceedings, shall I ask to visitors to come and be my witnesses in the court? Of course not. Probably I will ask to bring, to give me some accounting documents. For example, my income for the previous years was, let's say, £10,000. So this is my loss in this year because I don't make this money anymore. This will be the course of action, or I still need to bring some witnesses who will prove, who will tell that, okay, we were in this
No, I mean,
restaurant last year.
those days are gone. You have to give actual concrete evidence, in particularly on accounting. The difference between accountants and loss adjusters when it comes to accounting a loss, accountants look at it from an accountant's point of view. We look at it from an insurance point of view, and there is a difference. There's an old saying, there are lies, damned lies, and statistics.
Yes, we know it. Yeah, we know it. They say that it was Mr. Stalin who told us, but it is not. Yes, it is.
I have no idea. I have no idea. Let me give you an example. A lot of companies are going to turn around and sort of say, well, look, I want to claim for the rent I've had to pay out. Okay. Even though my shop has been closed, tough. You'd have to pay it out anyway. That won't be included. All that will be deducted from any claim. We will look, the way we will look at it is what is your loss of turnover, and then take away your standing expenses and everything else, and then the difference.
And also, I have a question related to the CIOC claim. You told me that there was a case in medieval times, so I don't know. Then it was related to CIOC of the vessel. And you told me that it was a big impact on the insurance industry. I didn't understand this case. Could you please elaborate a little bit? Because maybe you will provide us with more details, because I'm interested in the shipping industry as well.
Back on
actually, we have a captain here. His name of Alexander. He is sitting and smiling. Yes. He was deeply involved in these maritime issues, and he actually dealt with some English insurance agencies.
Right. Let me bring up the actual quote on this. Was it 1764? Just a moment. I have my notes here. The Mills frigate was a vessel insured by Lloyd's, and it went on a voyage and it sank. But the vessel was in a weak, leaky, and distressed condition. And what happened was the court case, there was a claim intimated, and the court case concluded with the agreement that a ship must be seaworthy before leaving shore, and that a policy could not even be paid on a ship which suffered from a latent defect unknown to both parties to the contract.
This is exactly what is written in Hague-Visby rules. I mean, they say that the vessel should be seaworthy, and the owner and is not the owner. The owner cannot rely on limitation liability clause.
No,
if the vessel was not seaworthy.
It's the both parties that you have to make no. In an auction, buyer beware applies. You go to an auction, it is up to you to determine what you're bidding for is what it says it is. It's not up to the auctioneer or the seller to determine. I'll give you a lovely example of that, of the buyer beware bit. There was an auction for a Banksy painting. Now, Banksy doesn't do paintings. And he did this painting, he made this painting, but he never wanted it sold. And it was taken to auction, and some Middle East gentleman bid millions for it. And under auction law, once the gavel hits the ground, that is it, contract made. Well, the minute that happened, the next thing you saw was this picture was being shredded. And built into the frame of the picture, Banksy had put a shredder because he never wanted it to be sold. and that nobody knows, was he actually in the place at the time? Quite possibly. And did he activate it remotely? We don't know. But when he hit, the gavel hit the desk, it suddenly started dropping down through the shredder and coming out of shreds. For some unknown reason, it jammed halfway through, so you had half of the real picture and half of the shredded picture. There was a huge uproar then, because the Saudi gentleman refused to pay, and the auction house said, no, deal done. But you should have inspected this, and you should have seen that there was a shredder there. It's your fault. No, buyer beware. It's your job to look at something before you bid for it. And they had to pay up.
Okay, so how it is connected with this insurance claim? I mean,
well, what I'm saying is that it's your job to ensure that a vessel is seaworthy. You can't just assume it's seaworthy.
How can I do this if I'm not the ship
specialist
captain? Yes, I can just come to the harbor. I see the ship. Well, it's ship. It's swimming. It's working.
Floating. It's floating.
Oh yeah, it's floating. Yeah, it's floating. And so, do I need to invite a specialist every time I come there, or ask for the documents, which just help me to analyze the?
Well, you have to remember, this was way back in 1760s. Ships were made out of wood in those days.
No, I understand this, but I think that the same prerequisite, I agree with Alexander Vladimirovich, I'm sorry, that it is the same stipulation we have in the international conventions, which say that ship should be seeable. How can I check that it is seaworthy? Yeah, seaworthy.
If my memory is correct, and Alexander, I believe you're a relevant captain. I think each vessel has a certificate of seaworthiness, doesn't it? Which is what the Lloyd's.
Alexander, this is a question for you, Alexander Kovalyov. Is it necessary for the vessel to have a certificate of seaworthy or something like that?
Alexander, your microphone is off.
I think your microphone is off. Well, your microphone is off. We don't hear you.
Oh,
yes,
it's okay. Yeah,
it's okay.
And yeah, at first, and John, thank you very much, and for your topic. It's very informative for us. Yeah, I'm Alexander Kovalyov. I'm from Vladivostok. I'm doing shipping as a manager, and before I have a shipping practice many years ago, and I worked in shipping company. I'm still working in shipping company, and as operator in the charter and to make charters. Actually, it's not simple question. Yeah.
Yeah.
Yeah. And anyway, if you would like to be insured, your ship or my ship, yeah, is you have a very lovely sample regarding paintings. Yeah. I suppose, and if we start to do something, we should know. We are experienced professional. We cannot doing and shipping or other deal if he doesn't know exactly what we can do. And if we don't know something as an owner, as a ship owner, we should be asked to be involved in the professionals and to hire these people and to pay charge and as experts like you, yeah, because and like surveyor or something like this, yeah.
I have never dealt with marine hull. I mean, that's a very specialized field. I've dealt with marine cargo, but not with marine hull. But I mean, basically what they're saying is, look, how can we insure a ship that's leaky because we know it's going to sink? That's basically what they're saying. And it's up to you to ensure that it's seaworthy before it goes to sea. I suppose you'd say, well, I'm only the owner, but I never see it. And the insurance company can say, well, we don't see it either. But isn't it a bit like saying ignorance of the law is no excuse? You don't
Yeah.
see all the laws, you don't know them. Oh, except in Northern Ireland, by the way, it doesn't seem to apply here. That's the only way I could look at it, because as I say, marine hull is not, it's a very, very special.
Yeah. Basically, the ship is like some plant or like enterprises. The same. This is a very high technology plant, and the same procedure, and not much differences. Yeah, but then we should find the people who specialize of this matter. Yeah, if it is like doctor, if we have problem with stomach, we cannot ask an oculist or something like this. Yeah, some another specialty people. Yeah, but then your information regarding COVID-19 is very interesting. Yeah, because I never met such kind of information before. Thank you very much. Yes, it's very, very, very interesting. Yeah, because I think in especially for in law society, it is very interesting information, and because we have the same situation in Russia, like we have in UK.
We have the same situation like in the UK, but we have nothing similar like they do have in the UK. So, for example, we do not have concept of business interruption at all. No one paid anything to our companies which are going to be bankrupt or already have become or went bankrupt. So this is completely different situation. I'm surprised that your company, your insurance company, will pay compensation for your companies. This is what does it? It means that you are living, John, in a let's say true business society. I mean, it is a fair society. For example, our insurance company, I don't know what do they do actually. You know, because every time when you want to get help from them. You do not expect anything from them. The only industry where they work is car insurance, so they can pay you for some car accidents. This is the only case I've heard. Insurance is not developed in Russia at all, so basically you are lucky.
I'm just trying to find something here that was actually, if I can find it. Yeah. This was on Twitter. Bar owner has to find COVID case within a mile to claim on his insurance. So obviously an insurance company is trying to wangle out of a claim. This is to do with the cause. And I don't think he'll have a problem doing it. So will insurance companies pay out? No, they will use every excuse you can possibly think of not to pay out. And that was a lawyer actually who put it on. We converse every now and again. The lawyer's particular answer was, I don't really understand this, given the overwhelming evidence that this guy didn't invent COVID to rip off his insurance company. They're taking, what they've done is they've taken that court the decision, and they're going to apply it to the letter, let alone the word. And I personally think he first of all, he needs to see what the limit of jurisdiction is, and then fight the insurance company on that. But I'm not getting involved in it. Although, hang on, Beer Riff Brewing Company. Oh, maybe I will get involved. Maybe get some free beer out of it.
Yeah, it's very interesting. Yeah, it's a very good case. Yeah, to research this. Yes, why not? Yeah. Mhm.
Just on this, just a very, very, very side issue. What do you call a herd of lawyers?
Herd of lawyers, what do you,
Gathering of lawyers. Yeah. What do you call them?
just lawyers? I've heard, just a second.
You mean in Russian or in English?
Rush.
In English.
In Russian stada.
Sorry?
In Russian, herd is stada.
Yeah, but if you had about 20 lawyers, well, we have them here,
Together.
in a room, what do you call them?
Just a gathering.
Just as assembly of lawyers. See? How do you call?
Somebody put up a headache.
Yes, but you know, all of our participants, they keep in silence. You know, they don't want to show up. Okay, John, thank you very much for your
You're welcome.
perfect presentation. You know, I'm happy that you gave us this speech today, and I very much hope that you will participate in other our events. For example, I would like to see you as my guest speaker. Maybe Zhenya also will ask you to come, and other my colleagues also. So we are very happy that you shared with us with your thoughts and ideas, and thank you very much for your time and consideration, and we'll keep in touch.
If anybody would like a copy of that judgment, I'll just put the
Okay. Yeah. Thank you very much, John. Yeah, for
you're welcome, Alexander.
Yeah, very, very nice information. I'm very happy for inviting me to join you. Yeah, thanks very much. Yeah, have a nice day.
And you, take care.
Thank you.
Take care, John. Bye bye.
Bye bye.
Bye bye.
Thank you very much.
So let's go to our other speaker. I think Mikhail Sokolov is on the line. Yes, or Michael. Mikhail, he is our friend of our department. He is my friend and friend of Mr. Vladislav Sokolov. And he, I will give some information about you. Yes, Mikhail, if you don't mind. Mikhail graduated from Tomsk State University many years ago, and then he went to Moscow and he practiced law here for many years in very prominent companies like Lukoil, and also he practiced law here in many international law firms. I know only about Norton, something like that. Yes. And then he went to the UK 10 years ago, and he has been living in London for the last 10 years, and or even 12 years, I don't know. And ladies and gentlemen, welcome, and Mr. Mikhail, we are all here. We would like to hear about your presentation. What was the topic? The topic is connected with the mergers and acquisitions and the effect that COVID-19 was on these transactions.
Yes, thank you, Vladimir. Can you hear me very well?
Yes.
Great. Thank you for the introduction. You made it easier for me to start talking. As Vladimir said, I'm dual qualified lawyer actually, and my original background is in Russian law. And many years ago, I became attracted by the glamorous life of international law firms and joined one of them. And ultimately, that resulted in that I qualified in England as a solicitor. So I prefer to say always that I'm a dual qualified, that I'm a solicitor in England and Wales, and I'm advocate in Russia. I'm still proud to be an advocate in Russia. Vladimir, thanks so much. Now, the topic is COVID-19 considerations in private M&A. I put briefly down the headlines of what I'm going to talk about today. COVID-19 has had a significant impact on M&A activity across the world and in various countries. Some sellers chose either not to sell or to defer ongoing negotiations and to wait for the better time for the sale of a company or attraction of investment. And some buyers might have and actually had difficulties with securing funding that they needed to finance acquisitions. At the same time, there were instances where it was a good time for investment. I think IT industry perhaps is an example, where the parties nevertheless chose to pursue M&A transactions in the current climate. And those who do not stay outside of the M&A activity should consider various measures of contractual protection. And the first thing I'd like to consider is the valuation of the target business and price adjustment. COVID-19 might bring uncertainty as to long-term financial results of the business. Put it simply, presently, not always possible or difficult to know the value of the target company with sufficient degree of certainty. Subsequently, this may, and in fact, actually results in differences between the sellers and the buyers as to valuation of the target business. Often, this results in the adoption of the so-called price adjustment mechanisms. Mechanisms that relate to the financial performance of the target business during the agreed period after the completion of the company acquisition. The examples of such mechanisms would be an earn-out formula based on the future performance of the target and its achievement of specified financial results, or alternatively, the buyer's contingent value right, where payment of a deferred portion of the consideration of the price, the purchase price, is conditional on the occurrence of a future event. On a separate note, in a short term, it may be difficult to see what will be the COVID-19 impact on the business. A potential solution in that case is adoption of the so-called completion accounts to determine the acquisition or the purchase price of the company. Historically, the completion accounts is the UK market practice. And there is a so-called locked box mechanism or accounts, which is a European market practice. In the recent years, in many instances, or perhaps in the majority of instances, the acquisitions governed by English law, the parties adopted the locked box mechanisms. In a situation where it is not clear what the impact of the COVID-19 on the financial results of the business will be, a party may want to push for the use of the completion accounts mechanisms, as opposed to the locked box account mechanisms. And the completion accounts, which is in effect a post-closing purchase price adjustment mechanism. Now, what is the difference between the completion accounts and locked box accounts? The locked box mechanism seeks to fix the equity price, the purchase price, at the time of the signing the share purchase agreement. The price is calculated using a recent historical balance sheet, a so-called locked box balance sheet, where cash, debt, and working capital are known amounts. To give you a straightforward example, in my practice, in the course of 2020, we negotiated the acquisition of a company. That was actually a Russian target company. And the locked box balance sheet was drawn on the 31st of December 2019. So simply speaking, it was the annual 2019 accounts. Typically, the parties negotiate and agree the definition of these amounts outside of the legal documentation. In other words, they negotiate the purchase price based on the lockbox accounts outside of the legal documents. And once agreed, they put it, the figure in the contract. The net price in that case is essentially agreed upfront. Yeah. As a result, the buyer typically assumes the risk relating to the ordinary course trading performance of the target during the period between the locked box account and until the completion. In the current climate, there may be significant adverse change to the target's working capital and debt position in this period. At the same time, in a fast-growing target business, this can provide significant potential upside benefit. In other words, the buyer may pay less for the business which actually is costing more than agreed as a consideration. And to reiterate, price of the target in this case is certain and parties know the final figure on exchange of contracts. Speaking about completion accounts, certainty of price is not the case with the completion accounts. Following the completion, completion accounts are prepared or on the completion date to determine the equity price, which is the amount actually paid to the seller. Neither party has certainty over the purchase price until the completion accounts have been prepared. The purchase price is adjusted by reference to a set of completion accounts showing the final position of the target at the completion. Then there is a dollar for dollar or pound for pound or indeed ruble for ruble adjustment to the purchase price. To the extent that the actual value of certain assets and liabilities is greater or less than the target figure agreed in the contract on the moment of exchange of contracts. The enterprise value of the purchase price, it's so-called, is adjusted for actual cash, debt, and working capital in the business. There may be other measures, such as net assets, which measures are taken and considered here. As well depends on the target's industry and basis of the valuation of the target business. If the parties choose the locked box mechanism, which is, to remind, the continental market practice, the buyer in such transaction is more than interested to negotiate and agree with the seller so-called leakage and permitted leakage. These terms are normally and often, which are always defined in the contract, in order to preserve the value of the business between the locked box date and the completion. Leakage is essentially can be defined as a transfer of value from the business to the seller or its related parties between the locked box date and the completion. Leakage, as I said, is a defined term, and preparing this this report, I just copy-pasted the definition of leakage from one of my contracts which I previously drafted. I'm not going to read you the whole because it's a pretty extensive one, but just the main lines. Leakage means in each case, by any group company, to or for the direct or indirect benefit of the sellers or any related person of any of the sellers, and during the period from but excluding the locked box date to and including the completion date. And that leaves any dividend or distribution, any redemption, repurchase, repayment of any share capital, loan capital, paying, incurring, or otherwise assuming liability for any fees, costs, or expenses, any management fees, service or directors' fees, bonuses, and some other things. The definition of the leakage is always is heavily negotiated between the parties to contract. But in which case, the definition of the leakage does not include any so-called permitted leakage. And permitted leaks include, again, this is subject to what the parties agreed in the contract. This include or may include any amounts provided for in locked box accounts, items agreed pre-exchange, payments of business costs in the normal course, arm's length intergroup payments in the normal course. And consideration to take into account when choosing between the two mechanisms, which is the locked box accounts and completion accounts, is the following ones. First, price consideration for a locked box are essentially the same as for the completion account mechanisms. Only timing differs. Secondly, a locked box approach requires buyer confidence because that involves robust financial information and minimizing the time lag between the locked box date and completion date, which is the key. The legal box approach simplifies legal documentation for the transaction because, put it simply, the parties agree the price by way of negotiation. You just put the figure in the contract. This is cost saving to adopt the locked box mechanism because no need to prepare completion accounts and review them after. However, the seller may not receive full benefit of continued ownership or operation of the business between the locked box date and the completion. That is because the definition of the leakage and of the permitted leakage will prevent the seller from conducting certain transactions. And in that way, the seller will be restricted. In the case of locked box mechanism, for the buyer, it may require to conduct enhanced due diligence and rely on warranties to gain comfort on the locked box balance sheet. Having finished with the completion accounts and locked box accounts, I'd like to move to another question of pre-completion covenants. If there is a gap between signing and completion, the seller usually commits to operating the target business in the ordinary course and agrees to restrictions on certain actions by the target during the period between signing and completion. The examples of the pre-completion covenants or obligation would be, for example, to carry on its business as a going concern in the way carried on prior to the date of this agreement, including not to depart from continuing its business in its ordinary course. Another example is not to incur any indebtedness or other liability or obligation, or incur expenditure in excess of a certain amount, or not to dispose or create any material encumbrance over the assets of the target business. This section in the share purchase agreement, which is very often called pre-completion covenants or pre-completion obligations, is heavily negotiated by the parties because, as I said, the seller is interested to have to keep as more flexibility as possible, and the buyer, of course, is interested to restrict the seller as much as possible to be confident that the assets cash will not be extracted from the business. Still, the parties should consider the extent to which the purchase agreement affords flexibility to the target business to respond to unforeseen events in light of the COVID-19. For instance, in fact, during the lockdown in England, as John said, many pubs and restaurants could make sales of drinks and food just to take away only. So people could not stay inside of a pub, which is abnormal for England, who knows, and who ever been in England at all. Certainly, this could not be called continuing its business in the ordinary course, right? It's not ordinary course at all. Equally, buyers should consider the incorporation into the purchase agreement of additional pre-completion covenants, which are specific to COVID-19. An example of that would be the target's compliance with government measures adopted in respect of its employees, for instance. Next, would like to discuss the right to terminate the contract, particularly with regard to the COVID-19 climate. In any M&A transactions, there is also a tension between the seller and the buyer as to the right to terminate the contract. Sellers normally don't like the idea of the buyer having right to terminate the contract because they want to have certainty and confidence that ultimately the transaction will be completed and the buyer will acquire the business. Whereas the buyer normally wants to keep flexibility and to have the right to terminate the contract, particularly if he becomes aware or receives some information adverse to the target. I believe everybody heard of the term material adverse change. And under the guise of the material adverse change, which is also called a MAC clause, MAC standing for MAC, a material adverse change, the buyer may want to have a right to terminate the contract in case material adverse change occurs. However, the buyers should not believe that a MAC clause automatically gives rise to terminate the contract because MAC clauses would be generally tended to capture events which are unforeseen at the time of signing of the contract. As a result, there are instances of traditional MAC clauses being expanded to cover the occurrence of limited and specified category of risk arising from COVID-19. An example of this would be the effect of the pandemic on the target's relationship with the key customers or suppliers, the forced closure of the target's facilities or premises, the impact of the pandemic on the target's workforce due to illness, or, for instance, a new place requirements adversely affecting productivity. All of these would be examples of the MAC clauses, but the preferable way to name these instances expressly in the contract to avoid recognition of the MAC clause not applicable in this situation. Alternatively, and maybe better solution would be for the buyers to push for incorporation of similar conditionality related to the target business outside of the MAC clause, just to prescribe expressly in the contract in which case the buyer has the right to terminate the contract, listing these particular instances. Next question to discuss is representations and warranties. Warranties are often heavily negotiated by the parties. And buyers should seek additional representations and warranties on the impact of COVID-19 on the target's business, including revenue insolvency, performance of material contracts, supply chain risk, employee benefits, executive compensations. And where specific COVID-19 related issues are identified by a buyer through due diligence, it should take a cautious approach and request the seller that the relevant issues are addressed at the seller's cost through a standalone indemnity. So a relevant indemnity clause should be incorporated into the contract, or a purchase price adjustment. Further, if there is a gap between signing and completion, the buyer should require that representations and warranties, particularly those related to COVID-19 issues, should be true and correct, and in that way repeated on the completion, which is often always resistant and often resisted by the sellers who do not like the idea of repetition of the warranties on the completion. Conversely, sellers may want to seek to limit their liability in respect of COVID-19 related claims by pushing for buyers to purchase representations and warranty insurance. And if the buyer has a recourse to such representation warranty insurance, it should ensure that COVID-19 risks are not excluded from coverage. And I'm happy to note that John told today about these issues. I will finish with discussing the limitation of the seller's liability. Limitation of the seller's liability is something which is normally or regularly pushed for by the sellers for inclusion into the contract. That, in my view, becomes even more actual in case of COVID-19 climate. And the first thing to discuss is a duty to mitigate. The contract very often says that the purchaser shall procure that reasonable steps are taken to mitigate any loss or damage which it may suffer as a result of breach by the sellers of this agreement. And another thing is the recovery from third parties. Very often, sellers are interested in the inclusion in the contract of a clause to the effect that before the buyer sues or advances a claim against the seller, it should try to recover from a third party. Buyers are normally reluctant to agree on this. And the compromise in that case would be for the purchaser to agree on recovery from a third party if that's reasonably available for him. Finally, exclusion of the seller's liability limitations. Any contract says that fraud is something which cannot be excluded. In my recent transactions, I pushed forward to supplement the fraud by the willful misconduct and willful concealment by the seller or any member of the seller's group or any of their agents. Although the contract provides for warranties and disclosure letters, willful concealment, like intentionally hiding some facts or information from the buyer, may and should result in the liability of the seller as well. And I believe I have finished with this. Thank you.
Thank you, Mikhail, for your presentation. The topic is very complex, as I see, very complex. And regarding to your last remark, you've told that you replaced fraud with the new wording, which is based on the concept of willful misconduct and
Yes.
intentional concealment of the facts, as far as I understood.
Yes.
Yeah. What was the reason for replacement? So I think my view is like we don't know what does it mean fraud. It is a very vague category. Was it an idea of replacement to make it more concrete?
Perhaps I had to be more precise, Vladimir. I didn't say replacement of fraud. I said supplement the wording of fraud with willful misconduct and willful concealment. With the other instances where the seller cannot avoid liability. Because you cannot exclude, you can exclude liability of the seller in many instances, but you cannot exclude in the event of fraud, and also said in the event of willful misconduct and willful concealment. So it's not a replacement, it's supplemental.
And we are talking about the contracts which are subjected or which were subjected to English law only, yes?
Yes, I'm talking about English law contracts, yes.
Yes, and my next question is about, I understand that now situation with COVID is more or less clear. We know that there is a disease which is called COVID, we know the results, we know that there are some vaccines and blah, blah, blah. However, I'm interested in the situation which was just after COVID started, let's say in the March of last year. Mm-hmm. And I suspect that there were a lot of contracts mergers and acquisitions contracts, which were concluded before COVID-19, but which were supposed to be executed after.
You mean
March.
completed after? Signed
Yeah.
before, but to be
Signed
completed
before
after.
and completed after.
Yes.
What happened with them? For example, based on your practice, to which particular provisions of these contracts you referred, or did you refer when you dealt with such contracts? Maybe you referred to some force majeure clauses, or maybe you referred some, I don't know, any other clauses you've told us today, like MAC clause, material adverse change. Was it a material adverse change, this COVID-19? Thank you.
Right. Well, first of all, Vladimir, this very well depends on how the contract is drafted. And I believe a seller will be in the position to push the buyer to complete, if he's still interested, of course. If the buyer, for any reason, for some reasons, for his own reasons, is not interested to complete any longer, he, of course, will be looking for an excuse. And creative lawyers, of course, may rely on various grounds for that purpose. They may rely on the MAC clause. In fact, I have never come across someone who rely on the force majeure clause in such case, but perhaps MAC clause would be of some relevance. Still, you cannot be vague, saying, well, you know, something better happened and I cannot complete for therefore. You have to be pretty prescriptive and detailed in explaining why you cannot complete. So some particular financial results worsened, for instance, and that is expressly prescribed and specified in the contract. That would be proper or more or less reliable ground to say, well, we're sorry, but we cannot complete for this particular reason. Otherwise, the more uncertainty you bring with you, the less convinced you look in the eyes of the seller, leaving him with a potential desire to sue you and to make you to claiming from your losses for your failure not to complete the contract.
Okay, and based on your experience, I mean, do you know how many sellers or buyers were succeeded to escape from the contract? I mean, in percentage, for example, 30%. For example, 30% of people, of buyers and sellers, they terminated contracts successfully based on the adverse material clause in the contract. Can we say like something like that, or it is unknown situation?
In fact, Vladimir, I did not investigate into this particular question, so I'm afraid I don't have any particular statistics. In my recent experience, the transactions which were in my conduct recently, there were pretty heavy negotiations to acquire some pretty group agricultural holding, don't ask me in which country. And the contract wasn't even signed, but not for the reason of COVID. In fact, it just parties didn't ultimately agree the purchase price. The next financial year would be more successful for the seller, so they potentially wanted to increase the price, and the buyers were reluctant to agree on the increase of the price. There were some other provisions of the contract which the parties have differences. So I wouldn't say that was heavily affected by the COVID. In fact, that particular business was not affected by COVID at all.
Okay, and the last question is related to, I mean, not situation with the COVID-19, but general to the mergers and acquisitions. As you know, recent changes, we have changes in our civil code regarding to indemnities and warranties. Based on your experience, what is the practice now? I mean, do parties choose Russian law as applicable to their transactions? Because now we do have warranties and representations and indemnity. Not, I mean, not they are not equal in all respects, but somehow it changed our practice. What people say in your community about these voices and representations? I mean, I would like to listen some positive view, of course. For example, you can say, all people in London are happy with this clause, with these new changes, and we all transferred from English law to Russian law, something like that.
For me, it's a very interesting topic. Let's refer it that way. You know, because before I became qualified in England, and I remember that was in 2006 somewhere, and I was speaking at the conference in St. Petersburg in Astoria. It was an M&A conference. And I remember I was speaking about the substitution of Russian of Russian acquisitions to not to English law, but to Russian law. And that was surprisingly the time when everybody believed that English law is something which is very good, very efficient, and in essence, actually, the only choice. I wasn't of that view, in fact. And I also always believe that if you buy a Russian company, perhaps it's very reasonable in for many legal considerations and for many business considerations to choose Russian law, not English law, in fact, actually. You know, a well-drafted contract very often has nothing to do with the choice of law. A well-drafted contract has many things to do with the quality of drafting, the concepts and wording which you insert and implement in the contract, right? Of course, the choice of law is very important. English law provides great choice. And the concept of warranties is very well, corporate warranties is a very well developed concept in English law, and has extensive case law helping the parties to the contract to protect their position. But I believe if you buy a Russian company, there are many reasons to choose Russian law. And ultimately, you know, I spoke in 2005 or 6 it was perhaps. And in 2010 or 11, they introduced the warranties in the Russian civil code. So I became fond of Russian law, and I believe that Russian law could be and should be an efficient choice in the acquisition of Russian companies. Particularly, speaking purely legally, Russian mandatory rules do not always correlate very well with the provisions of the contract covered by English law. So the efficient choice is Russian law, I believe, in many respects.
Okay, thank you. Thank you for your answer, and maybe other participants want to ask. Okay, only two persons participate in this conference from our side. It's me and Zhenya.
I also would like to ask two questions.
Okay, maybe Zhenya first, because Zhenya raised her hand.
I can give Alessia the floor. That's
Zhenya, go ahead.
Okay, Mikhail, thank you very much for your presentation. I have several questions actually, but well, I will start with these different ways of the calculation of the price. You said that there are two major, as I understood it correctly, the closed box and the
completion accounts.
Yeah, completion accounts. How do you choose between the two? What do you choose? Yes, how to choose between the two? Which is the most preferential, at least now, for example, or maybe there is something that we need to analyze before that. Which factors do we have to look through while choosing whether we use one or the other way of calculation?
Well, I'm afraid that does not have a simple and straightforward answer. The good thing is that with the locked box mechanism, the locked like ED in the end, like locked box, like закрытый ящик, да? Locked box mechanism. And the good thing is with the locked box mechanism, it gives you certainty. It's like you negotiated the price before you signed the contract, and it's fixed now and onwards in the contract. You don't have to take your time to discuss, to come back to the price issue again. You just negotiate it, put it into the contract, and things done in this regard. The bad thing is, if you agree the locked box mechanism, for you, as if you act for the buyer, that makes you feel uncomfortable because the figure is already agreed. It's a fixed price in the contract. But there is a time gap, always there is a time gap between this locked box date and not merely the signing of the contract, but the completion of the contract. Very often that may well result in about 1 year time, maybe 6 months, something. But because, for instance, one of my recent deals, the locked box date was 31st of December 2019, right? Because it's just annual 2019 accounts. We started negotiation in the beginning of 2020. That was long-lasting negotiations because parties was very much reluctant to agree on many things in the contract, like we discussed, warranties, indemnities, many other things. It's time-consuming process, right? So when we met October 2020, people started feeling very uncomfortable because time is flying. It's 10 months was over already. And in that situation, as a buyer, you really want to limit, as I said, the seller to do what is called leakage. In other words, to extract the value from the business. Because it happens often. Sellers are interested to take away and to keep with them whatever they can from their business. And very often this is just the cash, simply speaking, money or some valuable assets. Who can guarantee to you that you agreed the price, say 1 billion rubles, for instance, right? And after that, you took some cash for whatever reason, paying dividends, or you sold one of your valuable buildings to your company, which is actually controlled by you for some not really market price, no guarantee. So any buyer feels uncomfortable.
So
that may happen.
I'm sorry, so the buyer is the one who bears the risks that something might be leaked.
Yeah, this is the buyer who is interested to negotiate leakage and what is permitted leakage.
And what if they decide to leak it anyway? How do we guarantee or protect the buyer from this not so good behavior from the part of the seller?
Well, it's again that is dependent what is in the contract. You may have the right to terminate in that case, but the advisable thing is to say that precisely and expressed in the contract that in case they commit leakage and you find it out about this, you just terminate if you want. Or if they give away some, I don't know, smallish amount of money or pay some insignificant dividends or, I don't know, sold something which is not really that valuable, you may of course ignore that, but maybe you just will negotiate the price adjustment. But if it's something valuable, you may want to terminate subject to this is in your contract. Ideally, if you find it after the completion, you may sue the seller for the leakage.
So, can I use for example, a covenant which forbids them from, for example, leaking something? Can I say that you are restricted from leaking, for example, this or that asset, which if I may consider it the most valuable one, and but this is like a covenant or maybe guarantees? Can we use this mechanism in order to stop them from doing bad things to our assets, which we don't want to be leaked?
Yeah, it's a very good and complex question. There are various mechanisms to ensure that they will not do this. And just to give you a non-exhaustive list of such things is first, you always will have normally a section in the contract which is called pre-completion covenants or pre-completion obligations, which simply says you cannot do certain things as a seller. You cannot pay dividends, or you cannot, I don't know, sell assets in amount of excess of certain amount, or you cannot enter into the material contract, for instance. and material contract is a defined term in the contract. So you have express restrictions on the seller. The first thing you can do. Secondly, ideally, you can put indemnity clause in the SPA, saying in case you do this, you just indemnify to me, dollar for dollar, right? You can sell you can pay the dividends, fine, but you can compensate me after. You should compensate me after. Third thing to do is you always have schedule in the contract, which is called warranties, corporate warranties. You know what warranties is, I believe. So, and very often there is a separate schedule saying this is a list of buildings, or this is a list of bank accounts, and this is a list of land plots, or whatever is the material assets in the business is. And so you accurately list whatever is actually valuable. And real estate objects are a popular example.
And what is the limitation period in case I would like to sue them for that? Or it's also differs.
No, I'm happy to answer, but that again does not have as many things in English law. Does not have a straightforward and quick answer. But the short answer is, if you make an ordinary contract, it's a 6 years. If you make it a deed, it's a 12 years. But it's rare when a reasonable seller agrees on that. They always put a limitation clause in the contract, and they say, actually, they minimize the time periods within which you can bring your claims. And that's a so-called, like, they're not reducing the limitation period. They call it a notification period. So if you find out about the reason to sue the seller, you have to so-called notify it or him or her within a certain period of time. And that notification obligation very often consists of a few limbs. Very often the accurate seller wants to have a very complex limbs of the notification clause. First limb, for instance, if you found out about the grounds to bring a claim, you have 2 months or 3 months or whatever the seller wants to notify him. Once notified, after this, you will have to bring the actual claim into the court or into the arbitration institute within, say, half a year, 3 months, depends on very well of your bargaining power and negotiation position. But the seller will always be pressing you down, limiting you in all the possible respects, in all the possible ways. And you as the buyer will be resistant, saying, no. 2 months is, it's a very short period. If I find out something, I want to have some longer time. I don't know, I want to consult my lawyers. I want to consider this. And actually, you know what? Sellers always want you tell them everything, give all the details. They draft it their way. You have to give us all the details, blah, 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 of the claim. And buyer said, no, I don't want to give you any details, or at worst scenario, I have to give you just a reasonable amount of details, So that negotiation is always taking place. So the buyer wants longer time periods. The buyer wants to give you maybe some general notification, but he never wants to give you and to tell you everything what he discovered. And he never agrees to notify you, say, in 1 month after the discovery. It's too short period of time. He wants as long as possible.
Thank you.
No worries. Thank you.
Well, Alessa, your questions.
Yes, question. Thank you. I have actually a few questions for you too. First, I have a question about the non-compete clause. Is it enforceable in the UK? Because in Russian Federation, it's not. What are you doing with clauses like that?
The short answer is yes, it is available. The longer answer, the more unreasonable your restrictions, the less enforceable it is.
Okay, thank you. And I have a few more questions. For example, in some contracts, I see the clause according to which a buyer may seek to preserve its right to claim damages for breach of warranty on a contractual basis. It's ordinary clause, it's not a problem, but also claim damages for breach of warranty on an indemnity basis. What does it mean? Because in Russia, there are 2 different instruments, and the clause like this is meaningless. What about the UK?
Right. first of all, we have to distinguish between indemnity and warranty. They're two different things, right? And if we are talking exactly about the warranty claim, right? You normally claim damages, and you can prescribe the amount of damages which the seller, in case of the successful claim, have to compensate to you. So if you say in the contract that whatever I suffered or whatever I lost, you have to compensate me every pound, every cent, right? That's called to compensate on the indemnity basis. Let's put it simply, it has to compensate you totally everything what you suffered.
Thank you. So it's enforceable in the UK, right?
Again, that depends on the way the contract is drafted. No reasonable seller ever agree on that, but you can try.
Yeah, because we already have the contract with the clauses like that.
Which is why I don't like such questions, because very often people ask something about their particular methods.
No,
So
I'm just interested because my colleague told me that it's enforceable even in the Russian Federation, but I think it's not.
I think, Mikhail, it is better to give your disclaimer now. So you can give you this disclaimer.
Whatever I say is something to my disclaimer.
So because otherwise we will bring a claim to you.
No. You'll be my advocate. You'll be my advocate. You're appointed.
If I'm your advocate, you will lose the case.
Yeah. For the comment on your question would be, Alessia, is very often sellers seek limitation on the amount of what they will compensate to the buyer. In fact, I've never seen that the seller would not do this. It's either just direct loss, no loss of profit or no consequential loss. That is a popular solution. If not this, they often limit, very often, I think the vital majority of the situation, they limit the amount of their liability by a certain figure. It's either an absolute figure or it is a percentage of the purchase price. Say 50% or 20%, depends on the price of the contract. If the price of the contract is huge, 20% of the purchase price is a popular solution, for instance.
Thank you.
Alessia, any other questions?
I have one question, Vladimir Alexandrovich.
You can call me just Vladimir, because John he asked me several times, what does it mean, Vladimir Alexandrovich? Who is this guy? Let's agree, just first name.
Actually, I like the idea of speaking English saying Vladimir Alexandrovich.
Yeah, they don't understand what does it mean, Vladimir Alexandrovich. John asked me several times.
I'm usually asked this question also.
Yes, who is this Vladimir Alexandrovich? You know, I told him, this is me. This is my full name. Okay, Yana, go ahead.
Thank you very much, Mikhail, for your report. And you told us before that if the client buy company which is situated in Russia, it is better to use Russian law. And I have one question. Can you give us some example, maybe from your practice, when the client used in such situation English law and there were some difficulties? Before it, you told us about mandatory laws. Maybe you have some interesting case about it.
It's a good question, which is actually difficult to answer because my love to Russian law is irrational. It's absolutely irrational because I had enough with English law. Maybe I went back to Russia. Speaking seriously, one of the recent examples, a buyer was purchased in a Russian group of companies. They're rare by one company. It's normally just a group of companies, having holding companies and the structure underneath, right? So group of companies. And the applicable law was English law. Just by way of decision, because the sellers, they were foreigners, not physical individuals. The seller and the buyer were both legal entities, юридические лица. So they chose English law for some reasons. Maybe because it was an international acquisition, and they believed English law is protected very well, and indeed, is protected perfectly, both sides. That provides efficient mechanisms for protection of the seller by way of limiting its liability. And everybody has certainty that English law has substantial amount of case law addressing the issues of limitation of the seller's liability. And the buyer was protected very well as well, because we populated a vast schedule to the shared purchase agreement containing corporate warranties, and we also negotiated some indemnities. So both parties felt comfortable. The issue, I'm not saying a problem, because nobody had a problem until now. But an issue with this was the target company, the companies actually, were Russian legal entities. So the companies incorporating and existing in Russia, in various regions across Russia. And they were limited liability companies, общества с ограниченной ответственностью, right? So that means we all understand. You have to go to the notary office to certify the transfer of the participatory interest, right? So how you can reconcile English law contract with that mandatory provisions of Russian law, which requires you first to notary certify the share purchase agreement, right? And secondly, to transfer the shares. I'm tempted to refer it as to shares, it's actual participatory interest, доля участия, from the seller to the buyer. The invented mechanism was we had actually in essence two share purchase agreements. We had so-called framework or large share purchase agreement, which was governed by English law, and we had so-called Russian share purchase agreement, right, which was to be subject to notary certification. And we didn't show to the notary that large contract. We showed that small Russian contract. I don't have a particular issue with this, because large contract prescribed in details the role of that technical Russian SPA. We call it technical Russian SPA just because it existed for the purpose of satisfaction of the Russian mandatory requirements, right? So both contracts were to be made. But I don't have an ultimate answer to this. But my question, general question would be, what happens if the parties have a dispute and you have on the one hand English law contract, the large one, at the same time you have Russian act on ООО, закон об обществе с ограниченной ответственностью, containing some things as well. There is a potential conflict between the two. So the chosen venue was ICC, the arbitration, which is good in the way, because when it comes down to the hands of the arbitrators, these guys are very flexible. Vladimir Alexandrovich knows because he had experience with arbitrators. These guys are flexible. They happy to consider various factors and considerations. They're happy to accept many things. But in fact, I personally feel slightly uncomfortable with such things. You know, I'm struggling to give you a particular example. What an example of difference would be. But there is a potential, a conflict between the Russian mandatory rules and the English laws in that situation. Yes, of course, we said something along the line that in case of conflict or differences, English law prevails. Again, that is subject to the necessity to satisfy mandatory Russian rules. And as Americans say, the devil is in details, right? So when it comes down to the court, we will see what will be the solution. Still, I'm not a supporter of having such a potential conflict. So I believe better Russians improve their corporate law to convince people to substitute their acquisition agreements to Russian law, as opposed to having this not always natural combination of English and Russian rules. You know, an example of when English law can be well reconciled with domestic law is the laws of Cyprus and England, for instance, because Cypriot laws it's a common law. In Cyprus, they have common law because it's a former English colony, and their laws in no way, or I don't know the instances, in no way contradicts or conflicts with English law. More, it's a very popular choice. If you purchase shares of a Cypriot company, you choose English law. That's fine because it's very similar systems of law. It's both common law system. When you try to combine English law with continental system of law, which Russian law is, I don't think it's always natural. I know the case law in the English state courts. Actually, such things happen. That's fine. English judges have experience dealing with such potential conflicts and the necessity to find the solution when the Russian contracts combine with English ones. That's fine. Such things happens. But again, I don't believe this is always a natural combination.
Mikhail, I have a question just to elaborate this.
Thank you very much.
This issue. They, in your example, they chose Russian company to be a target in that deal. Why did they do like that? I mean, if I was responsible for drafting and negotiation all of this model of creation of this model, I would, for example, create some offshore company, the Cyprus one, for example, and then I would make the shares of this Cyprus company as a target for these people. For this transaction. Why did they choose a Russian company to deal with all these registration formalities? Did it happen because of lack of competence of the lawyers, or how it was happening?
They don't know
don't
you.
believe so.
He knows.
The only
Okay.
No.
Let's give us some insight, about this transaction. Yes, for example, there
is no insight, in fact. I'm not a supporter of complicating things. Everything flows from the people's mind, and everything flows from what is in the head of a particular project manager and what he believes in is the correct solution. In that case, I was instructed already after they chose the structure of the contract and the English law. So I was not in the position to change their minds. The transaction was well in progress, so I just wanted and was in the position to continue assisting them, to join their process and to help them to the extent I could. Again, whatever I have, even answering all your questions, I'm struggling to give you example whether it is really bad to have a small mandatory Russian law contract and to have a large English contract. In fact, if both contracts are properly drafted, you may avoid having any conflict or inconvenience. Still, I believe if you acquire a Russian company, just logically from all their business considerations, much more convenient to have a properly developed Russian law and to choose Russian law as the law governing the contract. Just more natural choice, I think. It's more natural choice. Now, in England, they have that reference, natural choice. That's a natural choice, I think. Still, well, it's not the first time I came across such situation. To give you another example is a few months ago, my colleagues from Kazakhstan, actually, they came to me with the instruction. I wasn't instructed in that instance, but they discussed with me the matter. They had similar situations. They had Kazakh law governed local acquisition contract, share purchase agreement, and they separated the indemnities and warranties into the separate English law contract. So that's another solution of the same, in fact. And I like the idea. I like the solution because they had properly drafted Kazakh law contract, no questions, but they wanted to have extra protection. Hence, they made a separate, completely separate contract, saying it's an indemnity and warranty contract governed by English law. I like the idea, in fact.
Well, Yana, any other questions?
No, thank you very much.
I have a question regarding this situation. We are talking about main contract and side contract. We call them side contract, yes, which is like stands alongside with this main contract. Well, I've never see any case which is related to this situation. For example, when we have two contracts, which is main and the other which is subjected to Russian law. But I thought about this situation many times. Mm-hmm. And what do you think? For example, what would be the proper course of action? Suppose that there was a breach of Russian contract, which also contains some warranties representations, which doesn't work in Russia for some reason. Can we rely in English court with reference to this case that there was a breach of warranties and representations in the main contract based on the breach of the same warranties under the Russian law, even if they are not valid here in Russia? For example, I can just develop the situation. There are provisions about warranties here under the Russian law, but still they are not developed. Yes. Suppose we drafted contract similar as you draft it in the UK. It is in all respects similar to English law contract, in all respects. Only one exclusion, it is subjected to Russian law. Everybody understands that if you go to the Russian court with this contract, it will be null and void for sure. However, we have a main contract which says that if something happened here in Russia, you will compensate. Can we elaborate? Can be elaborated something like that? I mean, the idea of these two contracts, is this idea of these two contracts to have two contracts in place?
Vladimir, I'm afraid in that case, I will start from the end. In that case, if I come to Russia, I'm afraid you will meet me say, Mikhail, you're welcome, but your contract is not enforceable in the Russian Federation for the contradiction to the Russian policy.
Yes. Then I go to the English court and ask them to compensate me because I failed here.
No. First of all, thing to understand is if you draft that complex set of contract, which is in my example was a framework share purchase agreement governed by English law, you incorporate into that, which I call for convenience a large share purchase agreement. You incorporate a Russian share purchase agreement to satisfy the Russian notary office, right? Your task is to make the small contract, the Russian SPA, consistent with the large contract, meaning both have to have the same choice of venue of consideration of the disputes. For instance, ICC in both contracts. Otherwise, if you say in the Russian contracts, Russian state courts, right? And the large contract, you say ICC, you already give rise to apply the possibility to apply for the parties to different courts, which is a disaster, just a disaster. So don't do this. So it's enough to have different laws governing the contracts. Russian law in the small contract, English law in the large contract. But please, 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 at least ensure that you have the same choice of venue in both contracts. At least that will help the case to result in the hands of the same judge or the arbitrator.
Well, I understand this perfectly. Yes, that we can see.
Answering your question, if you believe some clauses are unenforceable in Russia, but you believe the clause is enforceable in England,
yes,
and that clause is the English clause, well, it's a pretty theoretical exercise to answer your question. But I believe, put it simply, as a preliminary answer, if that clause is enforceable under English law, like an example of your colleague was post-completion restrictions on the party, on the seller, not to establish the same business on the same street, for instance, that's generally, subject to some exceptions, is enforceable in England, but that, as far as I understand, is not enforceable in Russia, right? So you can secure the proper judgment of arbitral award in relation to breach of this clause in England, for instance, on NCC, because you come to them and say, well, it's an English clause that doesn't that is not in the contradiction with English law. Please satisfy my claim. So you obtain the judgment or an award. You come with this to Russia because the respondent has assets in Russia to be seized, right? So you want to come to Russia because he has money and cash and assets in Russia. But I'm afraid you will have a problem with enforcement of the judgment of an or arbitral award in Russia, not because something wrong.
Of course you will.
Huh?
Of course you will be. You will have troubles to enforce it in Russia. It will not be enforceable.
In that case, you will be in the position to chasing his assets in different countries, which will be happy to enforce the judgment or in a vote. It's simple question, simple answer, I believe.
Okay, understand. So any other questions? Yana, Zhenya, Olesya, Dina Pavlovna. Dina Pavlovna has a question. We don't hear you.
We don't hear you.
We don't hear you.
But I don't have any questions, so I'm just listening to you.
Okay, so Alexander Kovalyov, our seller, our captain.
I'm afraid Alexander left us.
Alexander left us, okay. Forever?
No, he's not present at the moment.
Okay, Mikhail, thank you very much.
My pleasure. Thank you for inviting me.
For your participation in our event. I hope to see you again. So today is not a conference. Today is more like a round table. So I prefer to have a round table to have a discussion, you know, not to deal with the ordinary presentations. So the question and answer format is more appropriate from my perspective. So as you can see, it was difficult stuff when you gave a presentation, difficult for us, for example, but it was easy to understand when you answered our questions. So I prefer this format, and my colleagues as well, I think. I hope we will see you on our other meetings. For example, we have a summer school for foreigners in summer in June, and I would like to ask you to participate. Maybe we will create something based on this Q&A model as well. So, and if you have any questions, you can ask us. So, will you be able to participate, for example, in June?
If you believe I'll be of assistance, I'm more than happy to participate.
Yes, of course, but the audience will be a little bit different. Today we have a closed circle of the colleagues, and we are welcome to you. There it will be a little bit different audience, some foreign students, a lot of Russian students. They are not active like we, and maybe the material for them should be less difficult, you see? So maybe some simple.
You will guide me. You know, I don't have great experience.
Yes, just maybe to take one small portion, for example, volunteers representations, for example, and give them some ideas. How do they work, for example, in England, and what is the difference between Russian law approach and English law approach? Something simple, you see? Something simple. Because it's a kind of complicated stuff. But you know, as my colleagues see, you're a very good lawyer, very good professional. I know you for many years, and I'm happy that we have you as a guest speaker, and I'm happy that we have you as our professor to our new program. You know, we are launching a new program in English. It is called International Business Law Program for master students, and you will be our professor there. So and we also expect.
Sounds too important. Just a lecture, I believe.
What?
Just a lecturer, I believe.
Lecturer, professor, whatever you want. If you want to become a professor, I will create professor from you. If you want.
Maybe in the course of time, Vladimir.
If I can't do it, I will transfer this issue to Vladislav Tolstych, and he will create professor.
I'm beginning to be a little scared, but thank you.
Take care.
Thank you very much.
Thanks so much indeed.
Thank you.
My pleasure.
Thank you
for your questions. All your questions are very interesting and professional. I have to say.
Well, we have much more questions. And we will ask you our questions for many times in the future.
Yes, possible. I had to say if all your colleagues, Vladimir, have any further questions to me, you know my details, and I'm happy if you share.
I think it is better. It is better to come together and create some maybe a separate discussion. You know, maybe it is better. Maybe I will think about it. Maybe if you have a time, I will create some discussion of particular these acquisitions, mergers and acquisition transactions, because I have plenty of questions, for example, and 1.5 hours is not enough for me. And maybe we can set up something like that in May or in June. What depends, you know, what on your availability.
I'm not sure this is the time to discuss it straight away, but I had in mind just as an idea to combine my English and Russian knowledge in the area of mergers and acquisition transaction, and maybe to create some short course for 10 hours, whatever.
And if you have some colleagues, especially which have some UK background, they are also welcome to participate. We would be happy to hear them, you know, to talk to them, because of the language, you know, because we need to communicate not only with people who have Russian background, but also with foreigners as well. So please invite, you know, for the flexible discussion, no presentation, nothing like that, just a discussion, you know, they will be happy. Do not specifically prepared.
I will give a thought to who would be interested in that, of course.
Yeah, Michael, for example, you know, our friend Michael from Princeton, the firm we were working for. Yes, he was a good speaker, I think.
He's the head of international arbitration litigation in Vincent Mason. So
It will be perfect. It is perfect because Yana and Alessia, they all deal with, and Zhenya, they all deal with international arbitration. They are in charge of moot court competition here, you know, moot court competition. They for example, Yana, she is in charge of this of these matters. Yes, Yana, can you elaborate a little bit on this?
Yes, we create our mood in our university between students, and we just finished it. It was from 5th to 7th, yes, April, and we invite, I think, 100 arbitrators.
100.
Yes,
and
it will be very good that if we can meet with you and we have your contact to meet you in our next year. Yes, but
I have his contact.
Okay.
I have his contact. And I will not give you them. I will not give you his contact.
Just Google me. Just Google me.
Free of charge. No, no free of charge. I will sell it.
And Alicia, where is she?
She's also.
She create the case. It is very interesting every year. Yes, and she's the author of this case.
Wow.
Yes.
Oh, very good. Very prominent.
I was an arbitrator.
Yes. This year.
1 week ago. Yes, it was very complicated case. I was almost dying now to deal with it. You know, it was so difficult for me. Nevertheless, thank you very much, Mikhail.
Thank you.
We will look forward to work with you and to see you as our guest speaker. And maybe we will create something, some discussion about this, specifically these transactions.
We'll see. Thank you so much.
Thank you.
Thank you, Mikhail, and have a good day.
Thank you very much. Bye.
Thank you.
Bye.
Bye.
Okay, what we will do? Will we go further, or we will go to do our normal stuff? I think I will just show you my presentation. I will not give you my speech. I will just show you that I prepared. Okay?
Okay.
That I prepared, because people think, oh, he just put his name on the agenda and didn't want to give us the presentation. No. Alessa, could you please give me the rights for the oh, I have one. I have the rights. I will just show you. Maybe I will talk a little bit and then we'll close our session. Nevertheless, it was a good event. Yes. What do you think?
Yes, it was a very interesting report.
It was very interesting. It was very effective. John was good. Not it was a little bit difficult to understand, but at the beginning. But it is always better to ask questions, as I told you. It is more convenient and more profitable. Yes. And Jenny, thank you very much for the active participation. What can I do with this? How I can show you?
I think this is the program of today's.
This is the program. Do you see me? Ah, this is, for example, okay. How I can do it? I need to.
You
to
have
stop.
to choose the screen
Then,
with the presentation you want to show us.
yes, where I can find it?
When you share the screen, there will be several screens available. Have you opened the one that you want to show us?
I didn't.
Then you should just open and then.
Just open it. Okay, thank you. Sorry, I forget. Where is Olesya? She disappeared.
I don't know.
With my help, can you send me your presentation again?
No, it's okay. I'm opened. Now I'm opened. Okay, I opened. I just opened it, and then I will go to
share the screen.
Share the screen. Let's. Yeah. Okay. Here is the presentation. Yeah, this is the presentation. I will not talk more than 3 minutes. Don't. Okay. So actually, maybe I will give this presentation. For example, what is the topic of my presentation? The topic of my presentation is liability waivers in international contractual practice and relevance of COVID-19. What is the purpose? The purpose of my presentation is to give you a definition of liability waiver. The second purpose is to understand in which countries the liability waivers are enforceable. And the third is the approach of Russian law towards liability waivers. So let's start with the definition. Perhaps it will be interesting for you. Liability waivers are contractual provisions which release parties from liability in certain cases. To make my presentation more specific, I just wanted to provide you with some examples. This is examples of liability waivers from real contracts from my practice. I hereby release and waive my right to bring suit against the company.
Some problems with the sound.
You sometimes disappear.
I'm disappearing.
Yes. The microphone should be
like that. Are you hear me?
Yeah.
Are you hear me?
Yes, we do.
I do not hear you.
Vladimir,
are you hear me?
Yes, we can. Can you?
Now I hear you, but not so good. Nevertheless, I will continue. So what do you see now?
The slide with the texts of the waiver.
Liability waivers. Okay, let's see the first one. This is the typical liability waiver. I hereby release and waive my right to bring suit against your company in connection with the infection or spread of COVID-19 related to utilizing the company's services and premises. If you can see, this is a waive material right. And the second example, I give up my right to, just a second. Give up my right to, I do not see it.
Vladimir Alexandrovich, I think you need to change this.
I need to change what?
Much stuff.
Hello, can you hear me?
I can. Can you hear me? Vladimir
Hello,
Alexandrovich,
can you hear me?
Yes, yes, and we see. Yes.
can you hear us when we speak?
Hello, can you?
Yes, we can. Can you hear us?
Hello, can you hear me? Hello, can you hear me?
Yes.
Yes, so what do you see now?
Example of liability waiver.
Do you see them exactly, or is it everything clear, or something happened with the screen?
Yes, we can see it clearly.
Okay, so the second example of liability waiver is I give up my right to bring any claims, including for personal injury, death, etc. I may have to seek damages. And the question is for you. I will change the format of my presentation. What do you think about these liability waivers? What do you think about their enforceability and validity in Russia?
I think that the second one won't be enforced in any way because we are denying them the possibility to claim liability for the personal injuries. I mean, the death, the one that comes with the harm to the health and lives.
So it is not enforceable, yes?
I would say that it isn't in our country.
Yes, and the first one?
And the first one, I think that it might be enforced due to the fact that you are denying just the right of the claim concerning a specific corporate, I would say, right?
To bring, Zhenya, look, I have released and waived my right to bring suit against your company in connection with the infection or spread of COVID-19 related to utilizing the company's services and premises.
It's like a force majeure clause. I mean, when you say that you do not, they won't be liable for the problems in connection with something that you cannot control.
Well, first of all, from our perspective, the first clause, I think maybe it doesn't make any sense. Yes, it doesn't make any sense because if I do have some, for example, claims with regard to the company in these particular cases, I will bring it in any way. But looking, the question is where are they effective and enforceable? They're effective, these clauses, they're effective and enforceable in such countries like the United States and Canada and some other. However, there are certain requirements which should be observed. So these waivers should refer to negligence only, and they should not disclaim liability for intentional acts. This is the first requirement in the US practice. Secondly, they should be clear and not vague. Thirdly, they should be fairly negotiated between the parties. So it cannot be a scenario like you elaborated the contract, you drafted the contract and presented it to me, and I've just signed it and forget about it because we didn't negotiate this clause. If we didn't negotiate this clause, it would be unenforceable. Yes, go ahead.
So if we use the template, for example, the template for the contract which was used by the company for several years, and this company provides you with this template, you discuss several of the articles of this contract, but you do not discuss any of the waivers, does this mean that we have never fairly negotiated them?
It should be some evidence, I think, for of course, we are talking about court proceeding, yes, and it should be some evidence presented in the court where you need to prove that we specifically discussed this particular clause. If you do not present this evidence, perhaps you will fail, the case. The court will dismiss your claim. And the fourth requirement, they should be interpreted against the party which drafted them. So in case we have a dispute, for example, and I insist that the clause is valid and you insist that it is not, and it is established that I drafted this clause, of course, the court will take your side and will interpret this clause against me.
Vladimir Alexandrovich, this is the contra preferentum rule, correct?
Say again?
The contra preferentum rule.
Yes, of course. This is a contra preferentum rule. And the last requirement is they should not contradict the public policy. However, I found one case from the case of American case law. This is in this Vinikur against Pedal Pennsylvania Incorporated. So I can give you briefly description of the case.
Vladimir Alexandrovich, we can't hear you again. Can you bring your microphone closer?
Well, do you hear me well now?
Yes.
So something happened with my microphone. I don't know why. So
you bring it closer to your mouth.
I found one case in American case law. This case is Vinikur against Pedal Pennsylvania, very famous one. And this is a brief description of this case. Paul Vinikur was injured during a bike tour and brought a lawsuit against the tour organizer, Pedal Pennsylvania. Mr. Vinikur complained that he crashed his bike and suffered serious injuries. And in the court, Pedal Pennsylvania relied on waiver signed by Vinikur. And the waiver says, I hereby waive and discharge Pedal Pennsylvania from all liability as a result of my participation in a bike tour, whether caused by negligence or otherwise. And surprisingly, the court ruled that the liability waiver was valid and enforceable and dismissed Vinikur's claim. What do you think about this court decision? Do you agree with the court, or maybe you have some thoughts, a little bit, or opposite thoughts? Opposite to the court judgment?
Well, I can say that at least I can elaborate on the decision itself. I think that they could have ruled in favor of the company who organized the competition, due to the fact that they actually, most of this competition, even the bike ones, the running ones, they have these rules that you have to provide some certificates of health, and for example, the certificate of the quality of your bikes. So in case you were the one responsible for using this bike and this was your bike, why should the organizers be responsible for the fact that you broke it?
You see, we don't know the reason why this man fell down from his bike and why he crashed and suffered serious injuries. We don't know. But if we apply these standards, I've just talked about it, reference to the negligence only, not liability for intentional acts, be clear and not vague, be fairly negotiated, be interpreted against the party which drafted them. None of these criteria applied in this case, from my perspective.
Vladimir Alexandrovich, but we do not know whether it is, we only see one of the clauses, but we do not know whether they negotiated.
Yeah, but I've looked at the case materials and I didn't find any information about negotiation of this clause. It was definitely drafted by Pedal Pennsylvania, the tour organizer, so it should be interpreted against it. And the clause is not so, it doesn't refer to the negligence only. Look, Whether caused by negligence or otherwise, it seems to me that it covers also what is called willful misconduct or something like that. So in all respects, it does contradict what was said in the American doctrine. From my perspective, this is just an example of the story, you know. We have some criteria in the doctrine, and when it comes to the specific case, we do not find them. Perhaps we are not, because we are not qualified American. So in this, I will skip for some other issues. I want just to bring your attention to Russian law. What Russian law says about liability waivers. Basically, we have two articles in our civil code. These articles contradict each other. The one is Article 450.1. I quote, party to a contract may waive a certain right under the contract. So this rule can be applied only in sphere of entrepreneurial activity, but it provides us with the possibility to waive a certain right under the contract. This is a new rule which was introduced a couple of years ago. And there is a contrary provision in our civil code, Article 9, which says a waiver of rights does not result in termination of these rights. So how do they coordinate each other, both of these articles? And there is an intensive discussion in our doctrine, in our literature among the scholars and practitioners, which rule takes precedence over another rule. I did some research and I came to the following conclusion. If you're interested, of course. My findings are the following. Russian law recognize liability waivers and they are permissible, provided that some, say, criteria are met. First one, they should be specific, not release from liability in general. So it means that we cannot say, for example, I release the other party from all liability for breach of this contract. This will be unenforceable. The second requirement, liability waivers are allowed only in the sphere of entrepreneurial activity or business activity, as we say, предпринимательская деятельность. And the third requirement, they should refer only to contractual rights only, because other spheres of Russian law, for example, copyright or property right, we are not allowed to include in any documents related to these other issues, the liability waivers. But of course, they should not restrict the procedural rights of the parties. We know that there is Article 46 of the Russian Constitution, which basically says that, as far as I remember, that every individual or company has the right to seek legal protection in Russian court, as far as I understand. So it means that basically you cannot waive right to apply to the Russian court if there is a breach of your rights, for example.
That was one of the ideas under the Sony Ericsson case, I think, the decision in Sony Ericsson case.
What was the decision?
The Sony Ericsson case, when they had the alternative one-sided arbitration clause, and the arbitration clause provided that they could have, both of the companies could go to the arbitration, but only one of them could go to the state court. And in the end, they decided that it was null and void, but instead of making it null and void, they adapted it in favor of the party that didn't have the right to go to the state court, and they allowed both of the companies to go there.
Yes, it is a very good case, very good case. However, in our scenario, the case is a little bit different. I deprive you, I waive my right to apply to any court, not only arbitration, to any court in the world, for example, with regard to our issue, for example. I waive right to bring claim against you in any court in the world. So this will be from Russian law perspective, this clause will be null and void, I think, because it contradicts to Russian Constitution, Article 46. However, it is another question. We can discuss it for many, many hours. You know, I don't want to do it, especially considering that we do have lack of time now. And the last issue I want to touch upon now is the international practice regarding the liability waivers. We have Unidroit on international commercial contracts, and there is an article 7.1.6, which is called exemption clauses. Actually, this article is against liability waivers. Look, I quote, a clause which limits or excludes one party's liability for non-performance may not be invoked if it would be grossly unfair to do so, having regard to the purpose of the contract. So basically, this article says that if there is a limitation liability clause or any other clause which releases the party from liability and is grossly unfair towards the other party, it will be null and void. And there is an example or in the commentaries to the principle, an example which is connected with the example of like when there is accounting company A and it undertakes to prepare accounts for its client B, and the contract excludes any liability of this accounting company for the consequences arising from any inaccuracy in documentation. And as a result of serious mistake, B should pay twice more taxes than were due. And the question is, can accounting firm A rely on liability waiver or exemption clause in the contract? And the answer is no. It is the authors of the principle say no, the accounting firm cannot rely on this clause because it is professional party. It is supposed to know all accounting procedures and it is responsible for its work. Basically, I agree with the approach of Unidroit principles on international commercial contracts, and I do not agree with the approach of our US courts and US laws. In conclusion, there are three, let's say, findings of my presentation, of my short research. Liability waivers are enforceable in the USA, Canada, and some other countries which follow their tradition, but they are not responsible. They are not. They are not. They are not null and void in such countries like Russia and some European countries. And the choice of American law will not help because the interested party may always invoke so-called public policy rule, because we know that there is a rule that if foreign law strictly contradicts, for example, Russian law, foreign law will never be applied because it contradicts Russian public policy. So this is the end of my presentation. So I will not be happy to answer your questions because we have lack of time. And that's all.
Thank you.
Very brief. So who is the next? Alisa, welcome with your presentation. We are all ears. Alisa.
I think she just was here.
She was here and she disappeared.
Mm-hmm.
There are two Alisa actually.
Yeah, I think one is for her hearing and the other one is with the picture. Sometimes this happens.
Mikhail is always online. Mikhail, are you online? Yes, he's online.
I'm just thinking that I have to read again your book on the international laws.
It's a private international law.
Yeah, that is the one. Yes, I have a guess that what you said today is partly in there.
What do you have?
I mean, what you said today is partially covered in your book as well, I believe.
Ah, what I said in my presentation. Everything which everyone says is covered in my book. You know, it is book about.
That was very cool, you know. You have a source to
it is a very valuable source of knowledge. You know, as you know. Mikhail, when English course will cite my book?
Say it again.
When English course will cite my books?
Okay, it's a good question. At least we can do for you from my side to do something what I can.
It's a good question for you. You know, you need to cite me in one of your claims, and then English court will take your claim and put it in its judgment under the case, and then I will be one of the very prominent Russian lawyers because of you. You see? So let's agree on that. We'll pay you, maybe, after all. Okay, Alisa.
No, I'm afraid she's still not here. Alexander was just here, but then he left again.
Alexander left forever.
Oh, I see.
Mikhail, what do you think about death of Mr. Philip?
Of
the prince?
Philip.
He died today. Did you hear?
It's very difficult to say something.
What people say about it in the UK?
Well, it's a bad day for the whole country, I believe.
So all people are sorry about it, yes?
Of course, certainly. You know, the royal family is very important for the country. It's very important. And Prince Philip is one of the prominent figures, one of the most famous persons in the whole country.
And John said that Queen will follow, probably, in the next few months, because they are unseparated. He just wrote me.
I want to believe she will last for much longer. You know, it's not precisely for me to discuss that question because I'm not specialized in the royal family. But my guess is that there is an issue with who will inherit the throne.
Yeah, Charles
Right?
or William, I think.
Yes,
the question.
correct. Exactly, this is what I mean. Thank you.
Because people don't like Charles, but they do love William, and they believe that Charles should deny taking the throne in favor of his elder son.
Yes. Well, in fact, William looks, I don't know, to me, sort of prepared to take the throne, right?
For sure, he's young and he's loved by the people because of his mother, because of the effect he has on the people, and everybody loves his wife, I think.
Yes, true. She did her best, actually.
May I ask you a question? From my perspective, I've heard that William escaped from England and he is now living somewhere abroad.
No. You mean his younger brother?
Yeah.
Ah, it was another one. Okay.
He married a very famous American actress, and they decided not to be the part of the royal family anymore.
Yes. Is it William or
No,
it is
that
another?
was Harry. That was Harry, the younger brother.
Yeah. Vladimir, as a lawyer, I believe you watched a series called Suits, right?
You've told me about this movie many times, but I had no chance to see it.
Well, you're a busy person, of course, yeah.
Yeah, and she's the actress in the movie, in the series.
One of the main characters, yes.
The princess that married, not the princess, the actress that married Prince Harry, she was the actress in the Suits series. One of the main characters.
So I think you are one group of people of how it is called, сподвижники. You, Zhenya, Mikhail, Yana, and I'm separate. I'm a separatist.
I think you love the Suits movie series. It's actually very interesting. They show different styles of arbitrating and deciding on the things in the corporate way.
Mikhail, what case you are involved now? You've mentioned in our correspondence that you participate in some arbitral case, yes, in ICC, I believe, yes?
It's SCC, which is Stockholm. arbitration.
Stockholm. Now you're in Stockholm. Is there any difference between ICC and Stockholm? Not big difference.
In fact, it is a difference. If I can say to refer to that case which we conducted together, can I say that? Is it not a secret? Yeah. And in fact, I remember we communicated with ICC, and you did it actually on our behalf. And I like the way ICC is responding. I liked it more. They're like a friendlier, more sympathetic to your circumstance. They're happy to take into account whatever you're asking for. SCC, the Swedish, not the case at all. That case started. I acted for the respondent, and the case started in April 2020, just in the beginning of the lockdown in Russia. And my clients are a company from Ural, Chelyabinsk, in fact, actually, and they had various restricting measures in place in Chelyabinsk, pretty severe ones, like everybody had to stay at home, they could not visit office, some other measures. It's now we're fine, but 1 year time ago, that was different. And I remember we emailed and we made a few letters to the Secretariat of SCC, given all the reasons, explaining the restricting measures in Russia. Even we translated into English some local Chelyabinsk постановления and rules imposing the restricting measures, and we sent it to SCC. They gave us extension, but the minimal one. So they, in essence, in effect, they made us by any means, but they made us attend the case. Ultimately, we had no choice, but the clients had no choice but to attend the office and started digging the papers because we had to start to prepare the answer to the request for arbitration. So simply speaking, put it simply, they didn't give us any extension, the proper one.
So they're not cooperative, not so cooperative as ICC, as far as I understand.
Exactly. And do remember that in Stockholm, in Sweden, they did not have similar restricting measures which other countries had imposed.
Okay, I see.
Maybe that is the reason, I think.
So basically, it means that the main proceedings will be in future, yes? You're on the beginning of this proceeding.
No, we just finished the hearings, actually.
Okay.
And we're now waiting for the vote.
What was the online? I mean, was the online hearings
by video?
By video. So basically, you were in different countries, yes? What was the other part? From which country?
Well, the claimant was in China. The Chinese pretty huge conglomerate industrial company. The respondent is in Ural. The claimant solicitors are in England. It's proper English lawyers, the instructed ones. Their barristers are in England. I was in that time in Russia. And my barrister was in London, in England. We instruct barristers to speak in the hearings.
So basically, you apply the model we agreed with you before. So you have a barrister who speaks in the arbitration, and you just instruct him, yes, or prepare materials for him.
I spoke to actually.
Okay.
Yes, but mainly barristers spoke from both sides. That was just by agreement.
So the question is, was it convenient to settle the case through online, or it was not so convenient? How did you feel?
Of the case, what was the proper cross-examination?
Okay.
It's a good question, actually. You know, on the one hand, it is very convenient. You know, because if the quality of the connection is good, you don't experience or any sort of inconvenience. On the other hand, just know if you were everybody were in the same room, and if you want to say something that would be immediately noticed by the arbitrator or by someone else, so it's easier to intervene or to do something when you are in the same room. But when you all are sort of attending remotely, if you actually want to say something, you have to take some extra effort to express yourself. And so in the beginning, that was a little uncomfortable because, you know, I chose not to intervene, because if you interrupt your own barrister who is cross-examining the other party's witness, you like bring a certain harm to what he's doing. But sometimes I was intervening not to interrupt my barrister, but if their barrister was speaking something which was detrimental to my case, I could intervene. And that made me, you know, making some sort of extra efforts to be noticed, to express things. But, you know, took us maybe 1 hour or two, and everybody understood how it's working, and it wasn't any inconvenience at all. But saying that, I still believe that all the people are in the same room. You have much better perception of the people, in particular of the witnesses. You know, you put it simply, you see the face, and you have much better understanding of him or her as a person, which is important because when you are cross-examining a witness, many witnesses say and express that they are just lying, or telling untruthful things, or trying to avoid answering your questions. So, and what happened when a barrister was cross-examining a witness, you know, some people could put their eyes down, or to, you know, to put his eyes up, and you not always understood what he was doing, why he's reacting that way. Maybe his computer is sort of placed in sort of a angle, and that is convenient for him to look at you that way, or maybe he was avoiding to have a direct eye contact, or whatever it be. So although I think in the pandemic time, particularly, by the way, today's topic, that is of course a very convenient and often comfortable choice to have a remote hearings. I believe it shouldn't stop, in fact, in the future. And when it comes down to a complex arbitration or complex litigation, the preferable choice, a physical presence of everybody in the same room.
Yes, exactly. This is the point which I wanted to exactly say. The same with the teaching. I'm for distance teaching and remote teaching, for example. I'm for this, but when it comes to the big audience, where there are a lot of people in the room, for example, 60 or 50 students, it is difficult to give them lecture remotely through the internet by Skype or Zoom. Yes, and the same principle applies to the arbitration when it is a simple case, when the presence of the party is not required, and it can be done by Zoom.
When it comes down to expedited proceedings, that's fine. Very often, particularly as per the Stockholm rules, very often there are no oral hearings at all, by the way, right?
By the way, I have a question. Do they have expedited procedure rules as ICC have?
Are you asking everybody?
I think.
No, you.
Me?
Yeah.
So can you repeat the question, please?
Do they have expedited rules? I mean, in Stockholm, you know,
yes,
when
they do.
They do?
They do. They do, yeah.
And you?
It's called expedited rules, SCC expedited rules.
Yes.
Yeah, they do have, and the default rule in the expedited rules is not to have an oral hearing unless some party is requesting that, and an arbitrator is convinced that it is reasonable to have oral hearings. So in that case, if it's a pretty simple case, let's say, parties may have so-called case management conference, you know that. And we had about 3 maybe or 4 case management conferences in our cases. It's a pretty large case was. And I have to say that for the purpose of case management conference, that's fine to attend it by Zoom, or we used at that time TeamViews by Microsoft, which is fine, because that's no tension. We discussed some procedural things, but in fact, in some instances, our barristers and even we advanced our cases on the jurisdictional points, and that was important ones. But if you take apart more important matters like jurisdiction, and you simply discuss things like timeline, timetable, who does what and when, by which means the parties will submit the documents, that's fine to attend it by Zoom. In that case, I don't mind to have any Zoom conference. But again, speaking about interviewing witnesses, or when barristers advance their cases, I believe physical presence in the same room is, to me, still would be a preference. Perhaps someone will disagree, but I think next arbitration I will be asking for the personal attendance.
And when you had a communication over Microsoft Teams or whatever programs you used, I mean, was it safe? I mean, or did you use maybe a specific software?
No. It's a very important question, Vladimir. Actually, you asked me, and I tell you why. Because when we attended the case management conferences, we used what's the name? TeamViews. TeamViews
by Microsoft.
Like
yeah.
Views, yeah, by Microsoft.
Or
viewers, TeamViews, doesn't matter actually.
I do have it.
Yeah, so that was fine. But when we had hearings, the Chinese witnesses were physically in China. And China, as a state, they either banned or prohibit, or whatever it is, usage of Microsoft software.
Yeah.
So Chinese asked us if we are okay to using Zoom. And the arbitrator was not happy with that at all. You know why? Because speaking now, you can see the button. In my case, it's on the left-hand side on the top, called Zapis, recording in English. And if you just put the button, you can record it.
Yep, understand.
And it's okay at this particular conference. But it's maybe not okay when it comes down to the international arbitration, which is private and confidential. And any information should not be disseminated and go beyond the room.
Yeah, I understand.
You know, those actually are the problems that they've discussed this year during, like, I think 4 or 5 moods. One of the problems was always about the online hearings. We had the same problem in our competition. We had the same problem in Vismut, if you know what this is. And the main challenges when we were talking with the arbitrators and the arbitrators from different centers, all of them said that there are 2 major problems: the witness cross-examination and the confidentiality of the hearings. And they say that both of them are like the strongest arguments against this thing. And every time they have like hearings, and if someone doesn't want to have hearings, they just say, well, we have so many confidential hearings things to discuss, so please protect us. We cannot be 100% sure that nobody will hack this hearing. And there are so many examples of very secure conferences which were hacked. Even the Secretary of Defense's conference, I think that was, and they all of them said that it was that this is a huge headache for them now. But many of the arbitral centers, they develop their own secure systems right now. example, our RSPP,
Mind.
yeah, they have this Mind system, which is used also by the central bank, by the Ministry of the Finance. So it should be very secure, and they're very proud of it. But the same goes to the, I think, LCA and the ICC. They also developed some regulations concerning the online hearings, special regulations and recommendations.
Serious, we in our case, we agreed Microsoft Teams, it's called. I recall it now. And literally 2 days before the beginning of the hearings, the English lawyers who represented the Chinese returned to us and, well, actually, you know what? Zoom is literally, what? Okay. But that wasn't nice.
So what was the decision of the arbitrator in that case? You've told us about. I mean, they didn't agree to use Microsoft Teams, so they didn't agree to use what, Zoom? What did?
No, arbitrator in that case, he simply circulated an email saying that he received an application from the solicitors acting for the claimant, requesting Zoom, and explaining the reason, and just said, because the arbitrator, in essence, he is just a partner at a law firm, a decent one, but he's a mere lawyer, right? A decent one, a prominent one, but still he is a simple lawyer acting for a law firm. So, and he said, as per the rules of my law firm, which I work for, I have to ask for your express consent to the use of Zoom, because as per the policy of their firm, Zoom was not a secure means of conference. And we chose not to argue, in fact. We chose not to argue. To be ultimately precise, I don't think we have much to hide in this particular case. Even if that becomes public, perhaps tactically we would be in advantage, because we have many things to complain on with regard to the claimant. So we said just fine, we agree.
Yeah, I mean, it can be used, these tactics can be used, I mean, leakage, they can be used by the party which lost the case. For example, if I lost the case, I will put the record on the public, in the public domain, and say, hey, the confidentiality rules were breached. This is the ground for challenging of the decision, you know, based on the New York Convention, for example, Article 5.
Yes.
0.3. Yes, that was a good, you know, it is. Why? Because something happened with the Microsoft Teams program.
But they agreed to use Zoom. I'm not sure whether they could have argued that after that.
No, I mean, if I lost the quick case, for example, I take the record and put it in the public domain. And then say, someone do it. I don't know who did it. I don't know.
Clean hands doctrine applies, and they say we are not in breach of anything.
But this record in the public domain now, so the confidentiality rule is breached. This is the ground for challenging of the decision under Article 5, the decision award under the Article 5 of the New York Convention, because it is not, there was a breach of procedure. The confidentiality is a part of the procedure. So good. I will. I have a ground to challenge the award. Good strategy. This is the advice for you, Michael.
There were several cases decided on the online hearings, and they
Please do not consider it as an advice. I know that you're a professional. Yeah, this is a joke.
You know, the best skill of the law is research.
The research. So guys, Alessia just sent me a message that she is a moderator in another conference. Actually, I knew about that. She was supposed to do it at 5:00 p.m. So I was wrong. I forget. So let's close our session.
Thank you very much.
Thank you so much, and wish everybody has a good weekend.
You too. Where are you now? In London?
No, it's Moscow. I'm in Moscow.
Yes. Okay. Let's go to Banya. sometime tomorrow.
Vladimir, don't spoil the conference, please.
Okay, see you all, guys. Thank you very much for participation.
Thank you.
Have a good weekend. Bye bye.
Bye bye. Bye bye.